Okay, all speakers and panelists, I will go ahead and broadcast the webinar soon. Before we do that, just a quick reminder to have your videos and audio off for when we begin. And when your session begins, please turn your videos and audio on. Starting the webinar in 3, 2, 1. Hello and welcome, everybody. Thanks for joining us today. Welcome, everyone. Thank you for joining us for the second day of the first Regional Forum on Business and Human Rights in Eastern Europe and Central Asia, making human rights a priority for business. I'm Kavya, and I will be your technical facilitator today. If you have any questions for the speakers and panelists, please use the Q&A function. If you have any questions about Zoom or require technical assistance, please feel free to privately message Kavya Inside Pact for help using the chat box. We will also be providing English and Russian live interpretation throughout the forum. To listen to today's session in Russian, please select the interpretation button on the bottom of your Zoom screen, which is the globe icon, and select Russian. Similarly, to listen to today's session in English, please select the interpretation button on the bottom of your Zoom screen, the globe icon again, and select English. A big welcome to everyone again. Thank you for joining us for the second day of the first Regional Forum on Business and Human Rights in Eastern Europe and Central Asia, making human rights a priority for business. If you have any questions about Zoom or require technical assistance, please feel free to privately message Kavya Inside Pact for help using the chat box. I will now pass the floor to Anura Bekinova, Human Rights and Rule of Law expert at the UNDP Istanbul Regional Hub. Anura, the floor is now yours.
Thank you so much, Kavya. Welcome everyone to the second day of our regional forum on business and human rights in Eastern Europe and Central Asia. I'm greeting you on behalf of organizers, UNDP Istanbul Regional Hub and UN Working Group on Business and Human Rights. And before I give you a preview of today's day, let me share with you some quick reflections on yesterday's discussions. We had about 200 people participating from across Europe, UK, CIS, Central Asia countries, from many various sectors of society, including international organizations, governments, civil society, private sector, and academia. We also had a lot of people watching online, so please join today if you feel like that. The link is on the webpage of the event. So yesterday we touched upon very important issues. We spoke about the importance of business and human rights concept to the region. And we talked about that the regional dialogue is extremely timely and important to this region. Several countries, for example, during the discussion noted the need for exchange among countries, especially now because of a COVID pandemic, which has highlighted the vulnerability of people within supply chains around the world. So we really need human rights to be at the center of all decisions made related to businesses. We also discussed the need about raising awareness of countries on business and human rights. Very often it turns out that business and human rights is confused with corporate social responsibility. Yesterday, Anita, the chair of the UN Working Group, explained to us in her opening that business and human rights is not just about companies doing good. It is not about corporate social. It is not about corporate social responsibility, because corporate social responsibility is about voluntary actions a company chooses to take to be a good citizen, from charitable contributions to provision of services like education to local communities. But business and human rights is about when business is connected to harm. So our message is critical for businesses to identify the harms it is causing and work to prevent and remedy it. This is the biggest challenge, is we need to ensure that business is not done at cost of people's lives or their well-being. So let's please remember this core concept that business and human rights, or BHR, is about a business doing no harm, and this is about respect for human rights. We also had a very good quick orientation session about the concept of business and human rights prior to the forum. It has been recorded and it is available on YouTube, so please follow the link if you are interested. We also heard voices of business community, which recognized the importance of global guiding principles on business and human rights, and the need that businesses should not harm. Around the world, the expectations, of course, are very high that companies with support of government and other stakeholders will respect these principles. And this new trend of bringing mandatory human rights due diligence is very much welcomed by businesses themselves, but it needs to be more efficiently incorporated in their business practices. We have also looked yesterday at good examples from EU countries like Switzerland and Germany, which have told us about the national action plans that they have adopted. And this is a very right approach, because many national action plans have the power to gather attention and formulate goals and bring people and the whole of society on board. We also heard about good developments related to EU Action Plan for Democracy and Human Rights, which was launched this year, and that upcoming directive of EU on human rights and environmental due diligence that will be adopted in 2021. Well, we then looked at our regional developments, and it has been very clear that we have several countries in the region which are already having some promising practices in place. So, for example, we discussed Serbia's experience in developing a consultative national baseline assessment on business and human rights, and the advocacy that the Belgrade Center for Human Rights is currently doing around the need to implement UN guiding principles. We also looked at the Georgian experience that they have approved the National Action Plan and also established a working group to promote UN guiding principles on business and human rights. Ukraine's experience was also showcased, where we looked at the new strategy that they have developed on business and human rights, and also the chapter that they created within their human rights action plan related to these issues. We also had Russia providing some good insights about their approach of working with businesses about BHR concept and the regulations. However, it has been very clear that we still have a lot of challenges to be looked in our region. And one of them is how to make national action plans implemented and become actually true platforms for dialogue, most notably with enterprise representatives. We have seen that in many cases, businesses can be resistant to such regulation at the beginning, but we need really to learn how to speak their language to get them on board. The companies are also very often are not aware of due diligence practice, and even if they have interest to do so, and the governments also on the other side have lack awareness of how to incentivize these companies. So this awareness problem seems to be very specific to our region. We then had a very interesting side event by International Organization of Employers on human rights challenges that companies face in their supply chains in our regions. And one of the important issues raised was the need for promoting genuine dialogue between employees and trade unions. And it seems like in this region we're not there yet. So we looked at measures that can be proposed for this partnership, promoted ensuring conducive environment, addressing taxation, awareness raising about due diligence principles, and advocating for minimum wages. This is all in a nutshell about yesterday. For today, we will have an opportunity to learn, of course, more. We will look today at human rights due diligence tools and practices. We will also look at how to ensure access to remedy. And further, we will also have a side event for Southeastern Europe countries, talking about from voluntarism to obligation in human rights due diligence. With that intro, I pass now to Kavya to announce the next session. Thank you for your attention.
Thank you, Anura. Welcome again, everyone. Thank you for joining us for the first regional forum on business and human rights in Eastern Europe and Central Asia, making human rights a priority for business. Again, I'm Kavya and I will be your technical facilitator today. If you have any questions for the speakers and panelists, please use the Q&A function. If you have any questions about Zoom or require technical assistance, please feel free to privately message Kavya InsightPact for help using the chat box. A reminder that we are also providing English and Russian live interpretation throughout the forum. To listen to today's session in Russian, please select the interpretation button on the bottom of your Zoom screen, which is the globe icon to select Russian. Similarly, to listen to today's session in English, please select the interpretation button on the bottom of your Zoom screen, which is again the globe icon, and select English. I will now pass the floor to Sinisha Milatovic, Business and Human Rights Specialist at the UNDP. Sinisha, the floor is now yours.
Hello, Kavya. Thank you. Can everybody hear me?
Yes.
Great. Fantastic. In that case, hello, everybody. As Kavya said, my name is Sinisha Milatovic. I'm a business and human rights specialist with UNDP. I'm a human rights lawyer, and I specialize academically in this discipline. And it's a pleasure to have all of you here for a human rights due diligence panel. Just a brief introduction on the subject before we get into the topic. I'm not going to take too much of your time, but for those who are new, according to the UN Guiding Principles, which we discussed yesterday, as part of their responsibility to respect human rights, businesses should carry out human rights due diligence. Now, this human rights due diligence is a risk management process that requires businesses to identify, prevent, mitigate, and account for adverse human rights impacts with which they're involved. And it essentially includes 4 steps for each business to assess, identify, and assess its potential impacts on human rights, to integrate them and act on the findings, to track, monitor responses, and then finally to communicate and report on them. This topic has actually attracted a lot of attention in the recent past. Some have hailed it as the most important, let's say, innovation of the UN Guiding Principles. And especially in the last 5 years, it's really taken off with the adoption of legislation, primarily in Europe, that we discussed yesterday in our introductory session for those who were there. So we talked a bit about the French duty of vigilance law. Such laws were similar to those that have been introduced in a number of other European countries, as well as in Australia. And in the recent past, in the past year or so, the European Union has really taken on this subject with the announcement of Commissioner Reinders to introduce a directive on mandatory human rights and environmental due diligence for next year. There's a consultation process underway as part of a broader consultation on corporate governance as well. And as such, there is the idea that there is growing momentum on human rights due diligence, and that companies should get on board, and we should all countries, companies, other stakeholders alike think about what form of human rights due diligence we should have and how it should look like in the coming future. With regard to this event, the central objective of this session is to explore the state of play regarding human rights due diligence in Eastern Europe and Central Asia. And more specifically, we hope to explore the extent to which businesses in the region have sought to incorporate the requirements on human rights due diligence of the UN Guiding Principles, whether the current push from the EU and EU-based companies, primarily for a level playing field that I just referred to, has impacted the willingness of businesses in the region to carry out and to introduce strong and robust human rights due diligence processes, and the effect, inevitably, as all of these panels have discussed, the effect of COVID-19. So what has been the effect of COVID-19 on human rights due diligence processes? And then finally, what challenges are faced by civil society, governments wishing to ensure that businesses carry out human rights due diligence, thereby respect the rights of workers and communities. Now, this session will be more of an interactive roundtable, so we won't have any long presentations. We will have, let's say, quick fire questions to attendees in the hope to keep them and yourselves, our audience, engaged. We will start by asking initially businesses who cover human rights due diligence practice about their practices, and then move on to broader policy and legislative implications. I hope that's clear, and I will introduce each of the panelists as I ask them a question rather than now. So with that being said, I would like to kick off by welcoming Ms. Shubha Sekhar. She is the Director of Human and Workplace Rights with Coca-Cola for Eurasia. Welcome, Shubha. Thank you for joining us. And my first question to her is, can you tell us more, Shubha, about the human rights issues that you have had to deal with in the region, and how they were impacted by the pandemic, and what systems do you have in place to tackle them? Over to you. Thank you.
So greetings from New Delhi, India, and a big thank you to UNDP and the Working Group on Business and Human Rights for giving me this opportunity. Now, just to kind of give you an overview of the kind of issues, there are several inherent human rights issues in different markets. These are due to the various complexities, like, the systemic nature of issues in deep supply chain, complexities of supply chains, operating in, jurisdictions with subpar legislation or poor enforcement, subcontracting, lack of visibility, leverage issues, and so on and so forth, the number of issues. Additionally, as has already been mentioned, COVID has disproportionately impacted the vulnerable, and there is a deep connection between poverty, vulnerability, and risks. And when this happens, obviously, the issues get far more pronounced and exacerbated. And therefore, the criticality of the business respect for human rights is definitely going to go up and be more pronounced going forward. Now, Coca-Cola was an early adopter to the human rights framework and approach. In fact, we had a human rights department as early as 2005. Our first human rights policy was in 2007, predating the UN Guiding Principles. And of course, since it has been accepted in 2011, we've been very closely aligned in terms of policy, processes, due diligence framework. Now, just as the question was asked about the kind of systems that we have in place. So I'll give a couple of points based on the human rights framework that Coca-Cola has, and also experience of working in global supply chains for over a decade in some of the very complex markets in this region. So I not only take care of Central Asia and Eastern Europe, but also Middle East and Indian subcontinent and North Africa. So the first thing is respect for business can, respect by business can only happen if there is policy, processes, due diligence frameworks which are embedded in business. This cannot be something which is bolt on. Business, while of course there are people like me who have, been many years and have that, expertise, understand what it is. But at the end of the day, for it to be successful and to really, have it in walking the talk, it needs to be embedded in business. And this is, various functions need to come into play, whether it's, procurement, where who has the leverage, with the suppliers, whether it is, looking at new suppliers who come into the system, what is the kind of due diligence processes that are there, which the company has. It could be like a new plant being set up. So what is the kind of, human rights due diligence process that is available in, that's being adopted in plant siting. Similarly, agri-sourcing has certain other risks because of deep supply chain issues. And so does the company have frameworks which have human rights issues addressed for agri-sourcing? So there are a number of business decisions are complex. These are global, regional, local, and even the last mile where business is operating. So it has to kind of reach the last mile of business operations. Secondly, that even the due diligence framework and due diligence plays a very critical role, as has been mentioned by Sinisa. It is definitely a central role, and it will be continue to be a key role for this whole area of work. And greater the risk, greater is the need for due diligence. The third is that due diligence is not a one-time, effort. It is a continual process. It has to have a basket of tools. There's no one tool, and this has to keep evolving. So, for example, with COVID, where restrictions were there for people to travel, for meeting people, technology has to definitely play a role, and one needs to look at unique ways, interesting ways of, and newer ways of continuing to do due diligence despite the issues that the whole world is facing. So, for example, one of the important due diligence tools that we use, Coca-Cola uses in the 200 countries we operate in, obviously, in this part of the world, is our third-party auditing of all our supplier and bottler locations in all these countries. And this is something which is a very important process. It is embedded in our requirements, and this happens regularly. So each year we have something like 2,000 assessments. Until now, we've done more than 25,000 assessments. And as can be expected with COVID, auditors could not travel. They couldn't, go to the workplaces to check the adherence of the supply chain constituents to the human rights policies. So instead of twiddling our thumbs, we thought, let's look at having a remote assessments. And in fact, Turkey and the Central Asian regions were some the first places where we piloted this, and we were happy with the with the process, and we have included it as one more due diligence tool. This is not meant to remove the in-person assessments, which has its own importance, but to supplement it in these kind of situations like pandemics, or it could be zones of conflict where earlier one couldn't think of sending assessments, but we still have operations where we could look at these kind of use of technology. Apart from that, harms and risks can be plenty. In fact, one can fill pages of the kind of human rights risks and harms that can happen. But the expectation of companies is that they do the salient human rights risk assessment. The due diligence efforts need to focus more on the salient human rights risks. Now, for Coca-Cola, between 2015 and 17, we did a huge initiative where we reached out to stakeholders, both internal and external, took the help of, very distinguished consultants to help us identify the risks. And we've kind of identified 12 risks. This, not that we didn't know about this earlier, but it helped us, know that, yes, we are on the right track. And one of the, potential areas where we saw impact on people is the agri supply chain, specifically the sugar supply chain. So in several of our top sugar sourcing countries, we did third-party due diligence research to understand what are the issues. And closer home in Turkey, we have entered into a multi-stakeholder platform with FLA, 8 other F&B brands with our suppliers, with support of the government and other NGOs, where we were looking at understanding the issues that migrant workers faced in the agri supply chains, and in order to promote ethical recruitment of migrant workers in these sectors. Now, individually as a company, we went. So the migrants would come from the villages, and let's say they worked in our agri supply chain. They would work for a month and then jump category and go to some other supply chain. So if individually we did this work, we would not have been able to address it holistically. But because there are 8 brands, it is a far more holistic way of looking into the issue of ethical recruitment with migrant workers. Now, during COVID, understanding and appreciating that the risks could have increased, our partner did a due diligence and reached out to the migrants and the recruitment agencies, that is the labor contractors, and have identified some of the risks. For example, the young workers who are there, the numbers that has increased as a risk, and so there are a whole lot of, and the other findings, also very interesting findings. And the plans for the next couple of months would include training with UNICEF on child labor, use of young workers, what are the kind of safety mechanisms that are required, working with our suppliers one-on-one to have corrective action plans, to look at how can one work with the labor agents, labor contractors to formalize the arrangements with the migrant workers, and a whole other range of initiatives has been planned for the next couple of months.
Thank you, Shubha. That's quite a lot to take in. Thanks very much. There's a whole range of measures that you outlined there. I heard from you that you adopted essentially a variety of tools, and you focused your due diligence efforts on the impacts of some of the most vulnerable, including, you mentioned, migrant workers, which actually leads us to our next panelist, Ms. Aysun Sayın, who is the Chief People, Culture and Sustainability Officer with WPP, and also works with Global Compact Turkey. She's a member of the Working Group on Diversity and Inclusion. And Aysun, I would like to ask you in this capacity, as a member of the Global Compact Working Group on Diversity and Inclusion, what efforts have Turkish companies made to ensure that the rights of the most vulnerable members of the workforce, including, we all know well that Turkey hosts a large number of refugees, what efforts have been made to ensure that their rights in the workforce are protected? Thank you. Aysun, over to you.
Thank you, Sinisha. Is that okay for my voice?
Yes.
Okay, thank you, Sinisha, again. Thank you for all being here in the session. Actually, in that part, I would like to give some efforts and activities, what we did under the UNGC Turkey network. Then I'll share some examples from the company sites. As the first speakers mentioned about many of the initiatives existed in Turkey, like Fair Labor Association and the others, to collaborate with the companies to do due diligence and also supply chain sustainability. In Turkey, what we did actually regarding with the human rights risk analysis and management methodology, first, human rights due diligence and COVID-19 self-assessment for businesses. This is a tool developed by UNDP. We just translate beginning of the summer and translated in Turkish and made a pilot in our UNGC members. After all this effort, we organized a meeting to announce these tools all the business world, collaboration with ILO, UNDP, UNGC, and Business for Goals initiatives in Turkey. So we had a tool one of the businesses can use very easily in our website. After that, this is a self-assessment tool. Beginning of the 2019, in addition to the existing working group, we established a working group, Diversity and Inclusiveness, under the UNGC Turkey. And with the participation and representation of our participants, this working group defined the issues to be focused on in 2020. Actually, there are many issues we have to work on it, but we just clarified our 1-year aim actually to be more efficient and effective. We focused on inclusiveness of the LGBT plus individuals at work and their equal treatment at the workplace, and disabled people, and redesign of the work environment, and refugee people. As you know that Turkey, we are a hosting country in the world. Refugee to work payment and treatment at the workplace and their human dignity. We have just finalized a guide, name is Diversity and Inclusiveness Guide for Businesses. Under each topic, we give some practices and presented and KPI are provided which company can use. The list refer to these 3 groups and have been established by being inspired by the gender gap analysis tool. It's recommended that the companies use these checklists, KPIs, and they need to identify areas of the improvement. Actually, this is just a starting point for the businesses for the implementation of the policies if they don't have, based on diversity and inclusiveness, and to promote justice and equality in the workplaces. We just translate in English. You can find very easily UNGC Turkey website, diversity and inclusiveness tools. We hope that the business world will establish diversity and inclusiveness and their entire value chain, how important Shuba mentioned the first presentation. The business world take a leading role to reducing inequalities and to will take more steps to achieving sustainable development goals. In this the next year, we will focus on the other groups. This is just, you can think that like a series. So the next year will be focused on the other disadvantaged groups in our working group. Thank you.
Thank you, Aysun. Thanks a lot. There's a lot to unpack there. You've obviously covered quite a few different vulnerable groups and so on, and we'll come back to that later. But one of the things you mentioned right at the outset was this self-assessment tool developed by UNDP, actually the Business and Human Rights team in Asia, which was then translated into Turkish. And I'd just like to bring in our next panelist, with my colleague Seher Ariner, who is the Assistant Resident Representative with UNDP Turkey. And if you can tell us just a bit more about how this tool was adapted for Turkey and how it was used. You know, Aysun mentioned something, but if you can tell us a bit more, if you can expand on the use of this tool and how it was received by Turkish companies from your perspective. What is it that can be done more? You know, are these sorts of tools useful? And in particular, if you can focus on, you know, human rights due diligence, how well do you think this concept has been received by Turkish companies? Seher, over to you.
Thank you very much, Sinisa. Greetings, colleagues, distinguished participants. Let me also start thanking UNDP Regional Hub and the UN Working Group on Business and Human Rights to organize this important regional forum. It is first of its kind, I believe. And as we all know that the COVID-19 pandemic posed certain challenges to the businesses, the authorities, decision makers at all levels of the economy. And the confidence in the strength of the global economy and resilience of the institutions is going through a severe stress test. And in many countries, including in Turkey, many businesses endeavor to cope with these challenges caused by COVID. They provided assistance in medical supplies, engaged in initiatives for employees' well-being, and supported the communities affected by the crisis. You know, we are living in a country that hosts the largest number of the refugees, so businesses' support to this most disadvantaged communities is also very timely and very important. And in spite of the good examples of the businesses, there are also some cases that COVID-19 has intensified the tendency to disregard or deprioritize the human rights standards. currently it has been acknowledged by all of us. I believe that business cannot be ignorant to the vulnerabilities and human rights violations caused by COVID and other business-related reasons, and leave them this burden to only the government and the civil society. We as UNDP Turkey has been responding to these challenges in line with our strategy, Building Back Better, and addresses the issues of variety issues, including governance, social protection, green economy, or digital disruption. And we believe that the progress on each of these work streams will heavily rely on a proactive role to be played by the business actors. And therefore, we have been partnering with the Turkish businesses, as Aysun Hanım mentioned, and it is through some, bilateral means or through the global compact or the first Think and Do Tank platform of the private sector that UNDP supported from the very beginning. It's called Business for Goals platform, and this platform was established with the technical assistance of UNDP and in partnership with the two umbrella private sector organizations, TÜSİAD and Turkompet. They have a broad network at the local level and at the global level. So we use this as a leverage to just mainstream the human rights standards, the main issues that we would like to address in COVID-19 period. And we are currently in an effort to provide guidance to private sector, as I mentioned, the government, civil society organizations, to apply a right-based resilience lens to recovery issues, recovery policies. Through the platforms that I mentioned, we are also calling the action for protecting jobs, businesses and livelihoods to set in motion a safe recovery of the societies and economies. And if I come back to the, directly your question about the human rights due diligence and the rapid self-assessment tool, it is a tool that is developed within the framework of business and human rights in Asia, in Bangkok Center, and we use it as an example. We translate it into Turkish, and we test it in some of the companies. We get their feedback, whether some questions are applicable in their business context, and we make some revisions. And in a webinar, we launched this survey with a high number of businesses. And this includes also the platforms and the members of the platforms and the Global Compact in Turkey. If I have a brief introduction about the tool, I may say that it is offered to the companies as a partial but informative view of human rights actions, specifically in the context of the pandemic. And this rapid self-assessment is not a substitute for conducting human rights due diligence, but it's a tool, it's an awareness-raising tool for a specific emergency setting. It addresses around 50 actions that a business might take to alleviate human rights risks arising in the context of COVID. And if I may just go through some of them, one is, for instance, occupational health and safety. There are some questions, especially, addressing the gender dimensions. It assesses that how women have the proper safety equipment tailored to their needs and ensure access to hygiene products and gender-sensitive facilities. Another group of areas that we are assessing in this tool is the labor rights. And this rapid self-assessment is helpful and has been helpful as it provides references to the several ILO and WHO standards to guide the private sector and the businesses further. Another area is environmental and community impacts, and waste disposal, for instance, is becoming a much bigger issue among the public society. So getting the standard in businesses and supply chains may be required, and we just try to promote it in our work in Turkey with the private sector and the businesses. And safeguarding privacy, preventing stigma and discrimination, corporate policy and management considerations are the other areas that we have been addressing in this rapid self-assessment tool. And as a feedback, all businesses in Turkey are recommended to undertake this rapid self-assessment as an awareness tool in their operations and supply chains. And this comprehensive assessment of human rights impact should be done later as a solution to the medium and longer term impacts of COVID on human rights, and as long as the longer term consequences. And this paves the way to strengthening the trust built with the consumers, producers, employees, stakeholders, and the society at large in the post-crisis times as well, that hopefully we will just coming in very soon. So far, we observed that in Turkey, there's a quite high level of interest from the private sector, the businesses, and the awareness and interest on the UN guiding principles on businesses and human rights have been raising. And our platform and the Global Compact has huge work to support this agenda, and more companies started to adopt human rights due diligence as a central approach. But the rapid assessment tool that I mentioned is an important first step that also just increases the capacity of the businesses, just guide them on how to do a further human rights due diligence process. So we are happy to take part in this initiative. And we are also ready and willing to further support these partnerships in the private sector, and also public-private sector partnerships, just approaching to SDG 17. It is very important, I believe, to drive the businesses and human rights agenda forward and put the human rights due diligence at the heart of the business conduct in Turkey. Thank you very much for your attention. Thank you.
Thank you, Seher. That was very comprehensive. Thanks very much for that expose on how you use the tool and the work that you've done so far. So we'll switch our attention briefly from Turkey to Belarus, where our next panelist comes from. She is Miss Ekaterina Dekalo. She is an associate professor, at the Faculty of International Relations of Belarusian State University. Ekaterina, welcome. I want to ask you, your country, Belarus, has obviously been impacted by more than one emergency. There is currently, beyond the COVID pandemic, there is currently political instability resulting from the contested presidential election in August. So how have these two emergencies, and others beyond them, I guess, impacted the business and human rights agenda in Belarus, and especially human rights due diligence processes? Have companies in Belarus, including state-owned businesses and others, been able to carry out human rights due diligence? Do they have awareness of this? And has it been possible to even introduce the concept in emergencies such as these, where perhaps there are other priorities rather than this, according to some companies? Ekaterina, over to you.
Thank you very much. Good afternoon, dear participants. Thank you to organizers for giving the opportunity to share with our experience. Firstly, it's very important to highlight that promotion of business and human rights agenda in a specific country is a very multidisciplinary task. And it's not about just legislation at all. It's very important to have a proper ecosystem, let's say, in which there is a mutual cooperation of all stakeholders, which are playing each its specific role. And in this respect, speaking about the business and human rights agenda in Belarus, should be said that the topic have been brought to the country by civil society, and still in cooperation with academia, we are promoting it just by ourselves. From the state side is a 0 kilometer now. The topic is not on the agenda in general. We are not even talking about some special legislation on due diligence or even something. Besides that problem, there is a problem of the absence of that ecosystem that I'm talking about. There is a problem of absence of demand from the bottom, from the people's side, for respecting for their rights. And this is a lack of understanding in business community that respecting for human rights somehow influences on their business life, on the sustainability of their business, and actually that they should need to do this. But the main problem in Belarus is great extent of politicization of human rights topic in general. Human rights have been always perceived as political participation, and there is a just fear, sometimes just fear to work with this subject. And business has also this problem. So our huge problem, first, before speaking any specific things as due diligence or something, is just how to sell human rights to Belarusian business. And these two situations of emergency, actually no one had expected this, but they have brought very important changes. The first trigger was the situation with COVID-19 pandemic, and the second is our election campaign and the unprecedented peaceful protest movement that began after. So actually what happened, what the concrete reasons of these changes? First of all, is concentrated forms of disrespectful, inhuman attitude towards people from the state side in these two situations. Second is legal default, actually, as a part of this attitude. Absolute legal default now. And the resulting consequences of all this is unprecedented solidarity of people, civic empathy of people. So what changes, most important changes have happened because of these reasons that influence the business human rights agenda in Belarus. First, human rights began to be perceived by a large number of people not as something politicized anymore, but as something that concerns everyone's daily life. Consequently, updated society, actually, if I can say so, has new demands to stakeholders, including business. And actually, we have got a public demand for the observance of human rights by business. And the business, in its turn, could see very quickly that its loyalty to the person reflects on their reputation and consequently on their income, so they could see how it can be monetized, the human rights, the compliance with human rights. So actually, the society turned on very quickly blaming and shaming mechanism. We have blacklist of businesses which is supporting the regime. We have an application for the phone that scans the barcode of the product and allows you to understand which company supports their regime. It's made by people for people, and people use it very actively now, forcing business to meet this challenge. And business actually, as an element of society, had to somehow quickly to respond on this demand of society and do some due diligence, even just intentionally, although without any formal frame from the state side. And sometimes it does it just not to lose the consumers, but in most cases because of huge solidarity with people, actually. Of course, we are not talking about all business, and despite the fact that we have got these two situations of emergency as the point of entry of this agenda in practical way, the question now, very important one, how to turn this attempt of business to join the human rights agenda into a systemic approach, and not leave after these situations will and I hope not leave these emerging mechanisms of public pressure at the level just emotional impulse to support people, or on the level of witch hunt. And of course, without state participation as regulator is impossible. And I hope that our situation will change very soon, and we could manage to promote business human rights agenda in mutual cooperation among all stakeholders, as it should be in accordance with UN guiding principles. Thank you.
Thank you very much. That was a very interesting expose on the situation in Belarus. And as you said, the turn to business. Once the people started to demand it, the politicization of human rights. I would like now to turn to our, let's say, call him a guest of honor, because he woke up at 4 in the morning, to do this, Mr. Dante Pesce. He's the vice chair of the UN Working Group on Human Rights. To ask him, related to that, we've heard from Ekaterina on how people have caused businesses to turn to human rights and to respect human rights more, and to consider human rights due diligence as a priority. So what can we learn from that? And what can governments, civil society, other stakeholders learn in this sense? What incentives do you think can be used to ensure that businesses do comply with the UN guiding principles? So, or incentives, policy tools. We heard about one such incentive in an extreme situation of political instability. Are there other incentives that you would point to from the perspective, global perspective, with your experience as a member of the UN Working Group? Are these tools, are these liability regimes? Is it public pressure of the sort that we heard? Subsidies, positive, negative reinforcements? What can you point us to? What can you point governments, civil society, trade unions, and other stakeholders to in order to ensure that businesses apply the UN guiding principles, and especially with regard to human rights due diligence? Dante, over to you.
Yeah, thank you, Sinisha, and thank you for the organizers of this event, UNDP out of Istanbul, and Happy to be participating very early. As you said, I'm in Chile, in South America, where I live and where I'm from. So it's it's about to be 6 in the morning over here, but I have been awake for quite some long time. It's about to be 5 in the morning, actually. Okay, well, in any case, I would like to make, let's say, some opening remarks from the perspective of the working group on the issue of human rights due diligence, and happy to engage in what are the drivers, and maybe start there with the drivers. We see a driver on societal expectations on the rise, especially in some jurisdictions, notably Western Europe, but not exclusively Western Europe, and this event is an expression of that. We see market pressure out of the business-to-business relation, asking for greater transparency and accountability on the supply chain, so greater level of greater level of accountability on the supply chain. We also, and greater traceability, social, environmental traceability. We also see the regulators, especially in Western Europe, pushing into regulating human rights due diligence, and I will touch upon that in a second. But we see a regulatory wave, mostly in Western Europe so far, but we anticipate that this is going to have a spillover effect, and it's going to multiply around the world. And the investors are also pushing, and that's the fourth force that is actually developing and pushing this greater momentum that we're living around business and human rights due diligence. So this is, let's say, a context where the planets or the stars are getting aligned nicely to allow and to push into, let's say, greater normality, the practice of human rights due diligence, which still remains a patchy, let's say, a patchwork of initiatives, with the notable exception of Western Europe so far. But of course, we look at the whole world and we need to understand the different dynamics with different regional perspectives. The goal is the same, but the starting point is different, and therefore we're in different stages. The UN Working Group on Business and Human Rights that I represent has a mandate from the UN Human Rights Council to promote global implementation of the guiding principles on business and human rights. Since the endorsement of the guiding principles by the UN in 2011, corporate human rights due diligence has become a norm of expected conduct. The concept was fully integrated into the OECD guidelines for multinational enterprises, also the ILO Tripartite Declaration for multinational corporations. Human rights due diligence is a way for enterprises to proactively manage potential and actual adverse human rights impacts, with which they are involved. Enterprises should identify and assess risk by geography, context, sector, and business relationships throughout their own activities, both at headquarters and subsidiaries, and the value chain. The prevention of adverse impacts on people is the main purpose of human rights due diligence. It concerns risk to people, not risk to business. And this is a fundamental mind change that has not happened yet for the most part. The working group also considers that human rights due diligence is a key tool in the global efforts to build forward better in the wake of COVID-19 pandemic. We heard this at the UN Forum last week, the Global Annual Forum on Business and Human Rights, where companies and investors reaffirmed that having strong human rights due diligence systems, suppliers relationships, and supply chain visibility in place prior to the pandemic have been crucial for companies to navigate the challenge of COVID-19. The UN Guiding Principles also set out the legal and policy implications for how to operationalize the state duty to protect through a smart mix of measures that includes legally binding measures, particularly where voluntary measures continue to leave significant gaps in human rights protections. Indeed, the UN Guiding Principles anticipated the development of mandatory measures that codify the expectations of the Guiding Principles into hard law. The consensus among participants across all sectors and all geographies at last week's UN Forum is that laws are coming, Our future is one of mandatory measures. We now have a strong evidence base that voluntary measures aren't getting us where we need to be, or at least not alone. The announcement by Global Compact last week in support for mandatory human rights due diligence at the forum is a striking example of the growing consensus. Evidence highlighted at the forum by the Corporate Human Rights Benchmark and others also underlines again and again that the vast majority of companies do not even have a commitment to respect human rights yet. A number of company speakers at the forum generally welcomed mandatory human rights due diligence. Multinational enterprises want consistency and policy coherence across the many jurisdictions where they operate. Small and medium enterprises are looking for structure and guidance on how to effectively prioritize and integrate respect for human rights, and every business wants the level to be plain. Legislative initiatives like the one proposed at the EU level are critical for speeding and scaling up business respect for human rights. But building out regulatory responses is a key issue for the working group's ongoing effort to develop a roadmap to advance implementation to the UNDP of the UN Guiding Principles in the next decade through the UNGP 10+ project. Yet, beyond Western Europe, there are few mandatory human rights due diligence developments. And despite efforts to the contrary, there are also very few countries with national action plans, so-called NAPs. Not only have few countries developed NAPs, but also where such plans exist, the overall picture is one of shortcomings in terms of both process and content. One of the main reasons for the weakness of even NAPs, not to speak the mandatory landscape, is that in many countries is corruption the weakness of the NAPs in many countries is corruption and corporate and regulatory capture of the state. If the legal and policy process do not address this challenge and are underpinned by effective political will for change, it is hard to see how NAPs can make a difference in many contexts and provide stepping stones for more effective laws and policies. During the 2019 UN Annual Forum, the working group stressed that it was time for governments more actively to catalyze business respect for human rights. We recognize that local realities and contexts, including capacity and resources of government entities and other stakeholders, mean that different countries are at different starting point and that journeys will look different. Yet, in all contexts, there is potential for progress when learning from the experience of others and striving towards continuous improvement. In all contexts, two critical elements need to be presented for developing effective legal and policy paths forwards. Multi-stakeholder dialogue that includes both business associations and civil society, and importantly, affected stakeholders' voices, including unions, human rights offenders, and those most at risk. In spite of slow progress overall, the good news is that effective due diligence can be done. Practical examples are building up. The other good news is that proper human rights due diligence is also good for long-term business. It improves risk management overall, and it's good for both people and investments. It enhances competitiveness. We look forward to continued dialogue with stakeholders to envision a coherent and effective way forward for making human rights due diligence part of standard practice in this region of the world. Thank you very much, Sinisha.
Thank you so much, Dante. That was excellent as usual, even at 5 in the morning. Thanks very much for those remarks. There was a lot to unpack there. One of the things that you mentioned towards the beginning of your remarks is that there is, as you called it, a regulatory wave coming in Western Europe. And as I mentioned in the introductory session yesterday, Harpreet and we showed the laws that are on the books or that are being drafted, as you said, mostly in Western Europe on human rights due diligence. So one of the questions, and then you mentioned that this should have a spillover effect. Our next panelist is Christina Tebarles, the head of responsible conduct at the OECD. Welcome, Christina. It's a great pleasure to have you here. So my question is related to what Dante just mentioned, which is that a growing number of states in the EU, including France, Germany, Norway, others, have either introduced or are considering the introduction of legislation. And this has led to the EU, as was mentioned earlier, considering the introduction of mandatory human rights due diligence via directive in 2021. What impact do you think this will have on states in the region? In other words, will there be this regulatory spillover effect that Dante mentioned, or are you less optimistic? Over to you, Christina.
Thank you, Sinisha, and good morning, and very early good morning to Dante. It's a pleasure to see everyone on screen, and thank you for your question. Before answering, I would just like to give a bit of background on the work of the OECD on due diligence that Dante has also briefly alluded to. I would like to recall that most EU member states are also adherents to the OECD guidelines for multinational enterprises. Actually, 26 out of 28 member countries, EU member countries, are adherents to the guidelines. And there are also a number of non-EU countries in the region that have adhered to the OECD guidelines, including, for example, Turkey, which is also an OECD member country, as well as Kazakhstan and Ukraine, who recently adhered to the OECD guidelines. So the guidelines are recommendations from governments to business on how to behave responsibly. And they call on companies to carry out due diligence to identify, assess, and address adverse impacts in their supply chain. The guidelines use very similar language as the UN guiding principles and actually embed them in their text. But the guidelines don't deal only with human rights, but cover also impacts on the environment and other areas in which business intersects with society, for example, consumer rights, disclosure, corruption, competition, etc. So all countries adhering to the OECD guidelines, which are currently around 50 countries, have already committed to promoting and implementing the recommendations of the guidelines among business operating in and from their territory. This, of course, also means calling on these enterprises to undertake due diligence. And together with these countries, the OECD has developed guidance for companies on how to carry out due diligence. We have been working with companies and governments for many years in promoting this due diligence guidance and supporting their use by companies. So due diligence has been around for quite a while and has already become a market standard for RBC. We're seeing increased uptake from industry. In certain sectors, this is very advanced, for example, in the garment sector, in mineral supply chains. In other sectors, companies are already doing certain aspects of due diligence and may need to build on existing processes. For example, they have developed policies on due diligence. They're doing sustainability reporting. They're involved in industry initiatives in high-risk sectors. So they're moving towards a due diligence approach. And what we're also seeing, and Dante mentioned this before, is that investors and increasingly also banks are asking for due diligence, especially since the COVID-19 crisis. So investors are asking their companies to be more aware of the risks that occur through their supply chain. And importantly, the EU investor regulation, which goes into effect in March 2021, already calls on financial market participants to report on their due diligence policies. So this is in terms of background. So just to say that due diligence has been already being implemented by companies for over 10 years. So there is already a building experience in integrating due diligence throughout supply chain. But we also know, as other speakers have already mentioned, that this uptake is not enough. So clearly this move by the EU to develop mandatory due diligence as part of a regulation will have a very significant impact. So in terms of these impacts, we see that this will certainly provide benefits for EU business. Having an EU law will establish legal certainty on the issue of due diligence and level the playing field across business with respect to RBC expectations. And this we have heard over and over again from companies, that having a level playing field in terms of responsible business conduct is very important, especially for those companies that are front runners on implementing due diligence standards across their supply chain. Having an EU standard would also help companies to streamline cross-border processes, avoid conflicting laws and unnecessary compliance. So overall, having a legislation on due diligence will diminish costs for companies. Other benefits will be that companies will have a standard that will help them respond to the investor demands that I mentioned earlier. And it can also improve supply chain management, which, as demonstrated throughout the COVID crisis, is key to business resilience. And overall, it should also lead to a more proactive risk management, resulting in less downside risks and reputational cost. And of course, let's not forget that the purpose of due diligence is to prevent and mitigate harm to people and the planet, not only to meet regulatory requirements. So of course, having an EU standard will put the human rights and responsible business conduct agenda very high up on companies' agendas. So I think I will leave it here so that we also have a bit of time for questions and answers. Thank you very much.
Thank you, Christina. Thanks very much, and thank you for focusing on the effect that this could have on countries in this region, in Eastern Europe and Central Asia. I'd like to just come back to Dante briefly, just coming off of what Christina mentioned. You mentioned, Dante, that the future is one of mandatory measures. Essentially, they're coming, and so on. Regulatory measures are coming. I just want to see if you share this sort of, let's call it cautious optimism, if you will, expressed by Christina, which is, to ask you from the perspective of countries in this region, how do you think mandatory measures will come? What pressures or forces will lead to this? What about countries that may not be as exposed to global supply chains? Will there be similar pressures on them? Or do you think it's a domino effect caused by acculturation, whereby countries simply look at what one another is doing and eventually start to adopt the same measures one after another? Over to you, Dante.
Yeah, thank you, Sinisha. I will make an analogy with my part of the world, Latin America, which in some aspects is not too different from your part of the world. So the driver is clearly and has been not the internal policy development at the national level, but the driver has been trade and commerce for the most part. And through the value chain and pressure from clients, pressure from investors, because we have in general, in the overall global South, weaker governance and institutions that very often don't fulfill their obligations and don't have necessarily the capacity or the means. Sometimes there's lack of political will, but what we do see all over the world is that business wants to do business with others. They need investors, they need clients, and they want to be part of the global supply chain in one way or another. It can be directly or indirectly. So I will say the domino effect is more likely to happen despite resistance that might be taking place in one jurisdiction or other. And sectors, even in countries with very weak governance that are in, let's say, in a very problematic context, you will always have a local business sector that wants to be connected with the rest of the world and will be pushing in that direction. So I will say, in some jurisdictions, Western Europe and some other few places around the world, there can be a combination of factors, including internal pressure and policy developments from governments that want to be ahead of the curve. There are some notable examples, but the overall picture is that the driver is more the market or indirect, or the market based or incentivized by regulation taking place somewhere else. in many countries, the standards are not set in reality by the local regulators. That very often is a reference, especially when you have weak enforcement of legislation, or you have corruption or capture of the state. But nevertheless, the standards, the technical standards, have always been the industry-driven standards. And now the technical standards are incorporating somehow soft elements like good governance, transparency, accountability, etc., but also sound environmental practices and respect for human rights as part of the S of ESG. So I will say my optimism in the next decade to come doesn't come necessarily from inside our own governments and policy setting, but more coming from external pressures linked to market. And then what is promising, and you have seen it in Asia, also in Latin America right now, is the race to the top. And when we have a platform like the one that is being inaugurated yesterday in this regional forum, where you have the opportunity for peer learning exercises, that creates peer pressure. And that drives eventually a race to the top. That is something that might have some traction in your part of the world. So I also see with optimism the fact that we are putting together this regional platform as the first event that will be followed up yearly as an opportunity for peer pressure, for accountability and a race to the top, which is also the other, let's say, promising measure that we have been putting in place actually with you guys at UNDP that is showing positive signals that this is the way to come. So in short term, market more than other forces. In medium term, let's say 3, 4, 5 years ahead, I think the peer learning exercise that you're putting together should pay off well. And then, as I said, since the planets or stars seems to be aligning in the right direction, that is the opportunity where we can harmonize and align efforts in Eastern Europe and Central Asia as well. Thank you, Sinisha.
Thank you, Dante. That's a very optimistic view, not very, but fairly optimistic as usual, which is good to hear. My questions, I guess, to the panelists from now on will be, posed mostly from the perspective of somebody who is from the region and so on. And perhaps we in this region have, outside pessimism rather than optimism, but sometimes it's hard not to be pessimistic. So my question to the next panelist I want to ask, which is Shubha, it comes back to one of the things that we heard in yesterday's discussions, which is that the view of corporate accountability and responsible business practices still tends to revolve around the notion of corporate social responsibility, doing good, philanthropy, charity, and so on. So how do we overcome that? How do you work with your suppliers, business relationships, partners, and so on in the region to convey to them the responsibilities that they have under the UN guiding principles and to implement human rights due diligence and so on, rather than focusing on do-goodery and getting them to understand that they have actual responsibilities under the UNGPs. Shubha, over to you.
Thanks, Sinisa. I mean, as has been brought out, these are two very different approaches. Both, of course, have their importance, but the actions required and the kind of extent of the work is far more in the responsible business area. In the case of the UNGPs, sorry, there is some system update. Give me 1 second. Yeah, can you hear me? There was some disturbance in the line. Okay, so in the case of the UNGPs, sorry. The whole focus is on embedding it within the business. I mean, it has to be end to end. It cannot be bolt on. So as I had mentioned earlier, we are early adopters and we have a mature human rights program. So we started in this part of the world and of course elsewhere, but I'm focusing more here in about 2006, 2007, where we started, focusing a huge amount on building capability of both both our internal, internal stakeholders, that is our, the key functions which need to play a role in driving this within our supply chain, and our, supply chain constituents. So this was a lot of, capability building, where we're trying to build the business case, explain to them why is this important, why are we trying to do it, what does our, when we started, we didn't have UNGPs, but when the UNGPs came, that was an additional ammunition that we had to explain the importance, what was the expectation of business, and what did our framework require in terms of policy, processes of our supply chain constituents. Apart from that, we also kind of, took the help of our local teams, because if it's just the human rights people working on it, it is not effective. It is the relationship managers which need to come in. So we kind of worked very closely with our local business, the procurement teams, the technical teams, the human resources teams, and various other teams to start engaging with our supply chain constituents, and that really, made a difference. Apart from that, in very early days, we started the third-party workplace assessments to check, what is the adherence to our human rights policies. As I mentioned, this is an important due diligence tool, but not the only one. And as can be expected, in initial days, there was a lot of non-compliance, and it took us a long time to get them to, engage, take corrective action and move. But as the cycles kept on happening, and, our capability building kept on, it was something which was a continual process, not one-off. We saw far more adherence to, the requirements. Apart from that, the whole program was a collaborative approach. It was not fault finding. There are limitations to fault finding, and the only way, of going forward is really making, the constituents comfortable to say that this was, in our interest. It is like a family where we need to kind of constantly look at what are the issues, within ourselves, and, proactively address it. Apart from that, it is very important for all the people who are either in the, already started or going to start, is that unfortunately there is no magic wand. There are issues which are systemic, there are deep issues. And so the only way which, what we have learned in several years of operating in the field is that the messaging has to be continual and continuous. Every opportunity needs to be found, and these cannot be just standalone human rights, but when there are business discussions. So for example, when there are supplier meets, which is there for, the relationship building, we used to take the opportunity to make sure that we were also talking about human rights. So it's a kind of a very, integrated approach, like a continuous approach, rather than, coming in bits and bobs of messaging, but every opportunity was taken. And also we use the leadership, and obviously in our company, the leadership appreciation and drive is very much there. And we took the opportunity to even get the leaders, when they were talking about business and other requirements, to also talk about importance of, sustainable and responsible business. So, that's been our journey. Of course, there's always learning. It's not, the end of the road. There is constant learning. COVID has taught us other things, but, this has been some of the highlights and of our journey.
Thank you, Shubha. Just a sort of follow-up question, if you can extrapolate from what you were saying to, beyond your company to other companies, stakeholders, and so on. Are there any broader lessons that could be learned from this process, I guess, for those wishing to promote the UN guiding principles, right, and the business human rights concept in the region? And what would you say are the biggest barriers to this? I would also like to kind of focus on what are the opportunities. So every barrier also has an opportunity. But some of the important requirements, is the leadership appreciation and driving within the organization, especially in the human rights. It has to go down the organization. It cannot, like a very effective and a fantastic CSR team can be standalone and do some fantastic work, but in the business and human rights world, it cannot be just the human rights team. It has to be a very integral approach. So a challenge is that, if there is no leadership drive, but the opportunity is where that is there, then, the needle will begin to move. Apart from that, there are times where there are leverage issues, so even big brands like such as ours, not in every category are we big buyers. So there is a leverage issue. So in those kind of situations, it's important to look and see what are the kind of
approaches that you can use. So instead of saying we can't do it, so for example, sugar is we are important institutional buyers, but very, very small percentage of what is produced is bought by us. So in situations where we wanted to kind of drive this work in sugar, we kind of went and under the AIM progress, where there's several other brands, 40 other brands who are stand on a similar platform of wanting to be responsible and have responsible business frameworks, where we started holding joint sessions. So we kind of got 7 big brands who were buying sugar, and we got our leadership to get the pool of suppliers together and started talking this kind of language that it is important for all of us. So we need to kind of see how can we look at various approaches, whether it's industry to industry or multi-stakeholder approaches to start moving the needle. Apart from that, as is well known, and it's repeated, the mantra is collaboration. Definitely that is the way forward. Individually, I think in this decade, 9 years since UNGPs have come, as has been pointed out by Dante and others, there was a lot of changes and a lot of movement. It catalyzed movements, whether it's regulatory, whether it's stakeholder expectations. But I think the next decade, the writing on the wall is very clear that everyone needs to get out of their silos. There's only so much that individual organizations can do. It's only when there is cross-sectoral collaboration of like-minded partners working constructively can one really start moving the needle. And the example that I gave of the Turkey Fair Labor Association and 8 brands with common suppliers, NGOs, government supporting, I think is really the way to go to kind of drive sustainable solutions in supply chains. Thank you.
Thank you very much. Thank you for that. I'd like to just go back to Christina for a second. Christina, you noted the uptake of the OECD guidelines in the region. You mentioned Turkey, Kazakhstan, Ukraine, and so on. And you also noted their close relationship with the UN Guiding Principles, which would obviously indicate how important it is that the UN and OECD work together, as they do in many other parts of the world, which we obviously hope happens in this region as well. Now, one of the areas of overlap is corruption, and we heard Dante mention the importance of combating corruption, the corporate capture of the state, and so on. The OECD's responsible business conduct approach also includes a focus on corruption. Bearing all this in mind, what would be the priority for those wishing to combat corruption in the region? Is there something unique, or is it the same recipe as everywhere? Over to you, Christina.
Sorry, I had to unmute myself. Yeah, that's quite a big question. And you're right. So the OECD guidelines don't only cover responsible business conduct related to human rights, but also in relation to corruption and business integrity. And at the OECD, we already have a huge work program to deal with corruption. We have the Anti-Bribery Convention, which is a binding international legal instrument. And a lot of work is done under the oversight of the group dealing with this convention. We also have a large part of the OECD dealing with all aspects of integrity. So integrity in the public sector, and we work with all these parts of the OECD as part of the work on responsible business conduct. So, and we know that corruption can be a major barrier to responsible business conduct, has huge impacts on human rights, also diverts very significant financial resources from other priorities. So clearly, dealing with corruption needs to go hand in hand with promoting a responsible business conduct and human rights agenda. So certainly for us, this is a topic that is important in this region as it is in other regions. And just to go back to what Dante said regarding the governance in his region in Latin America, where corruption and integrity is also very high up on on the agenda for responsible business conduct. Here again, we also always make the link between the necessity to deal both with corruption in company behavior and in governments as a way to implement the responsible business conduct agenda. So clearly corruption is a barrier to responsible business conduct. So the learnings that we have from other regions in the world are of course essential also for this region. Doing due diligence, looking at all the risks in the supply chain, not only human rights, but also integrity risks, is one way to deal with risks of corruption. So by doing due diligence, companies can also assess whether they have the tools in place within the company to identify links to corruption and corruption occurring throughout their supply chain. So the due diligence approach is useful both to identify impacts on human rights, but also to identify deficiencies in companies' own structures to deal with corruption. So I don't know if you want me to give more detail, but certainly, I mean, due diligence is a tool that helps identify all kinds of risks that companies are faced with, including, of course, in their own operations.
Thank you very much. I will come back to you if we have more time. I just want to ask a couple of other questions of other panelists. I want to go to Ekaterina. Ekaterina, you mentioned the huge obstacles faced in Belarus. You mentioned the lack of demand initially from the people themselves. Let's call them consumers, but I mean the public at large as one challenge, and then you also mentioned the politicization of human rights as another. The human rights were politicized. Now we've seen both of those dynamics play out in various other countries in the region. I mean, that's true in many other countries as well, both of those things. Short of a major political crisis, which we hope to avert in many other countries, and which has led to security threats and challenges and so on, and is ongoing in Belarus. So short of that, what have you learned about how we can influence companies beyond having a major political crisis? Is there anything that can be done? Is there anything that you would have done as a business and human rights advocate differently prior to the instability caused by the presidential election and demonstrations afterwards?
Thank you. Thank you, Sinisha. Yes, actually, what we in the academia now is actually I'm collaborating as an expert with Belarusian Helsinki Committee, and Belarusian Helsinki Committee is the oldest and the biggest human rights defender organization, and is leading in this topic of business and human rights, the only actually human rights defender organization who is dealing with this, and we are working together. So before this, what we have done, what we can do actually, we have done a lot of initiative concerning education, enlightenment, about all this topic of business and human rights, about difference between corporate social responsibility and business and human rights. Actually, we in 2018. In last year, 2019, we have developed and adopted updated version of country guide. Actually, initially, the Danish Institute of Human Rights in 2015 have developed country guide, their traditional country guide for Belarus. But the problem was that because of all these reasons that I described in my presentation, this country guide did not work, and we started to think how to make it work. So we've updated it, and we put there not only analysis of human rights violations by business, but we put there in simple words. It can be, if it can be say so. We explained the provisions of UN Guiding Principles. We explained what does mean violations by business of human rights. What does due diligence mean? What does mean? Why is it different from corporate social responsibility? And we've put as well there some practical tools how to do some all these procedures. And about grievance mechanism in company. So it's like we've made such a textbook for a business and for a state, actually, and civil society. So, and we put relevant examples from Belarusian context just to make all these things and these guiding principles more adaptive to our context and to our stakeholders in state and business and civil society. And in addition to this, as I have already said, our main problems, how to sell human rights to business, how to explain them that the compliance with human rights is not just good thing, although it is, but it's influenced very much on your sustainability as business. And today, in today's like economy, you know, as a knowledge economy, where the person, the human, is the center of all economic process. So, and the safety of a person is the safety of a business. So, and we've developed as well such a brochure and analytical review about benefits for a business from compliance with human rights. Why does business need human rights benefits for a company? And we explained in detail with examples from good international practices and with examples from some Belarusian business who is a part of global business, what you will have for sustainability of your company if you will comply with human rights, and what you will lose if you are not, risks of, for example. And we do this, and now we are working on developing some database on the human rights violations in context with all this our political situation. It will be a huge database concerning the violations by business of rights of workers in connection with their political position and in other as well other related questions. So the violations of people's human rights in connection with this our situation. So that will be such data open database. We are working now on this. So that's what we can do. And of course, I mean, there is a big part that can be done and have to be done from the state side, but unfortunately, we can't say nothing about this yet. And it's not on the agenda on the state, so we're doing what we can do. And of course, I agree as well that we're trying to explain to our business, as Dante was saying, is absolutely true, that if you want to be part of global world, if you want to develop your company, if you want to be successful and sustainable, and today, even if you're working in the one jurisdiction, and even if you don't have some your parts outside Belarus, you anyway have to follow this international frame because you're working anyway with some other outside Belarus business, let's say. So you can't not to be in this frame if you want to be in a modern business society in general. So that's that we can explain to them, and we try to do this.
Thank you very much, Ekaterina. I want to, we refer to the dynamics that you just mentioned earlier about demand, lack of demand, and explaining to the public about what's different about human rights violations by businesses, and then the politicization of human rights. I just want to come to our other guests from our other panelists, from the region, from Turkey, which is Aysun and Seher. How true are those dynamics this is a question to either or both of you, whoever wants to answer. How true are those dynamics in Turkey? So lack of demand, meaning lack of public awareness about what human rights violations by businesses represent, and a lack of demand to have to have businesses be accountable, and then also the politicization of human rights. How true are those? And if they're not true, why? If it's different, especially with regard to a lack of demand if it is true, so if there is a lack of demand by the public to deal with this issue, what can be done about it? What can be done? How can the public be, let's say, taught, or how can the public's awareness be raised to ensure that it demands that businesses do the right thing? Over to you, perhaps Aysun, if you would like, or Seher, whoever would like to answer. Aysun, maybe.
Okay, thank you. I don't know. I'm not sure about. I have an answer actually. The one answer: lack of demand. Yes, in some sector there's very lack of demand, but I can observe that in my sector, in communication world, and others who use the technology or white collar people, they are demand their rights and they want to more inclusive workplaces. But when we're talking about the majority who works there in the sectors, even if there's a demand, there's no chance to that people who ask their rights. That's the reason we collaborate together under the UNGC or Business for Goals to create the demand and their voices. So in Turkey, some issues are very political to advocate LGBT rights. Even if the global company, it's a hard topic in Turkey to advocate these rights. But when you came together under the UNGC or other initiatives to advocate the LGBT individual rights, this is easy. You are not put your company in the targeted in politically way, but when collaboration, it helps our life easier to do something for the refugee, LGBT, and sometimes in the women. So the answer is, one is these initiatives, these platforms are very, very important for our lives. And the second one is raise awareness in our employee and to give them a chance, to give them a platform to ask what they want from their identity, what is the definition of the human rights in their context. This is the answer, I think. But in general, you're right, it's not easy, every topic, to work on it very publicly or advocate as a business people.
Thank you. Yes, go ahead. Sorry, say ahead.
Thank you. If I also have a broad response, this is the same issue, not only for the businesses, but for the whole public. There is a lack of awareness on certain rights, and Turkey's human rights agenda is not so much progressing in recent years. But there are, definitely some institutional setups, the National Human Rights and Equality Institution, the Ombudsman Institution. These two public bodies are, responsible for raising the awareness among the public on certain rights. This includes the rights that should be promoted by the businesses as well. So this is a general phenomenon in Turkey, but I agree also with Aysun that the main rationale for us to support this business platforms, Business for Goals. This is the first Think and Do platform, is to just disseminate this knowledge, know-how to the businesses and to their networks as well. So the promotion of human rights, its principles in businesses is promoted in these platforms, and increasing of these platforms is very important. And it is also important to provide the linkage with the public policies. Public-private partnerships in the field is also very critical to increase the demand. And that's why, we are working hand in hand with both the platforms and also the public side institutions. Thank you.
Thank you very much to both of you. I have a question to actually to Shuba and to Dante on third-party auditing, because Shuba, you mentioned third-party auditing. You said that that's one of the tools that Coca-Cola uses. So my question is, how effective do you think it is? Because we've actually heard lots of criticism from lots of stakeholders saying that it's a snapshot, it's a spotlight. So my question to you is, from your perspective, how effective do you think it is? And the same question to Dante. how does the how does the UN Working Group view third-party auditing as a tool? Over to both of you.
Thanks for your question, Sinisa. As I had mentioned, due diligence is like a basket of tools. If it's just one tool, then there's an issue. Like everything, there are pluses and minuses. Now, think about third-party auditing is that it is part of the routines. It is done regularly. So it is an extremely important tool that if we get rid of, then how else do you kind of check each and every workplace, especially for a multinational like us operating in so many countries. So to sum it up, I would say it is definitely an important tool, but it cannot be the only tool. It needs to be used along with other due diligence. Again, the due diligence being focused on salient human rights risks, where one goes deeper and where there are issues, there are country-specific issues, regional issues, then we kind of adopt other due diligence tools. So for example, in the foreign migrant workers. So the auditing, when we started in 2007, that's when the red flags started coming, that there was passport retention, there were issues. Now that helped us, immediately get to know, and this was long before the, the various, legislations came into being, the first one being California Transparency Act in 2012, 2013. So that's where we started getting, into deeper. We conducted a research to understand what is this, what are the drivers. We found out that there were three big drivers, which is the passport retention, the contract substitution, and the fees, the recruitment fees. And then we started doing other initiatives, to address that. So I hope I've answered your question about the due diligence, the auditing as one of the tools that we use.
Thank you. Yes, you have. Actually, Dante, before you answer your part, I would like to scrap that question to you and just ask you an audience question and then a related question from myself. We have a colleague, I think, asking if we had to prioritize 3 top business and human rights issues in the region, which ones would we agree upon? And a related question from me is, looking forward, we hadn't mentioned in this session, but it's obviously been mentioned elsewhere, the UN Working Group has engaged in the Next Decade project to set a path for implementing the UN guiding principles in the next 10 years. So how do you think the concept and the practice of human rights due diligence will look? So, and what will businesses in the region have to change in the next 10 years? So I guess the first question is about top 3 priorities on business and human rights. And the second one is on how do you think human rights due diligence will look and what companies will have to change in the next 10 years? Dante, over to you.
I was getting ready to answer the other question on auditing. So yeah, so let me touch one point there. Actually, I'm in agreement with Shubha in terms of a toolkit of measures, and auditing it can be a good complement, but it's not in itself what actually works better, because it can be for monitoring, it can be for following up, it can be when you have a good grievance mechanism, you will have early alerts, and auditing can be a good measure for following up on the early alerts where they're coming from and going deeper. But that will not replace something that is key in order to make this happen, which is the commitment from the top. And that it's linked to the question that you're making now, Sinisha. We need the board to understand what are the relevant risks for human rights, or the salient risks for human rights. And we need the CEO to understand that. In the case of Coca-Cola, that is very clear from your CEO. And we need this leading from the top. It's not only the narrative, but is also allocating the necessary means to translate that narrative into something real. And that is something that is key, actually, factor. Our leaders, the leaders of business, the CEOs, need a mandate and support from the board to say, know and show. Who should know? The decision makers. About key or significant human rights risks to be prevented, to be avoided, and to provide remedy in case of failure in terms of prevention, in a transparent manner, putting, let's say, engaging and committing to your key stakeholders, and also be able to collaborate out of the comfort zone to have difficult conversations and to engage about those salient human rights risks in order to address them, use leverage, collaborate with others, the pre-competitive space, leveling playing field, etc. So all of that is part of a combo, and auditing will only work if there is a true commitment to address human rights impacts. It is if it's really being embedded into the normal practices of the company, and that requires mandate, political will, vision, leadership at the end. In terms of how human rights due diligence is going to look into the next 10 years, I will say, based on the evidence that we have right now and the curve, we want to exponentially speed up and scale up. Our ambition is to make this conversation normal into the next 10 years, not to be on pilot phases, individual companies, some innovators, front runners, but to normalize and to make it part of a normal conversation, just standard good practice. As we have at the operational level today, health and safety should be standard good practice, or at the corporate governance level, good governance in terms of anti-corruption and integrity should be normal business practice. Well, my expectation and what I think it is possible is to turn both at the governance level and at the operational level human rights due diligence as part of standard, just normal good business practice, not even good, I'll say just standard business practice. And that is the, let's say, thinking in the ambition into the next 10 years. I think that is possible due to all the elements that we have in front of us. And because we're building a coalition of the willing. So we're building a coalition of unions, civil society, indigenous, industry associations, the mainstream ones, IOE, the employers, ICC, the Chambers of Commerce, and many others actually that are industry specific are supporting the project that we are leading in terms of stock taking the first 10 years, learning the lessons that need to be learned, and actually developing the roadmap for the next decade. And I think we have conditions to be cautiously optimistic in terms of the ambition into the next 10 years. And of course, whatever is in our hands as a working group, we need to, we want and will push this agenda forward. And I think it is possible, should be possible, and is actually needed to be possible. We need this to work. And I think, if we all put and align ourselves into the same direction, we can aspire for greater transformation, uptake, and normalizing what today is, let's say, a pioneer level exercise, but normalize it fully within the next decade should be possible.
Thank you very much, Dante. That was wonderful as usual. Thank you for those insights. It is now 1 minute over time, so I would just like to echo Dante's call to thank all the participants, to echo for the wonderful insights, for their views on and their experiences, and to echo Dante's call to build a coalition, the willing, perhaps to expand it to a coalition of the reluctant and possibly unwilling as well, but to have them on board in advancing human rights due diligence in the next year or so until we convene again at the second regional forum, hopefully next year. We think this is a good first step to have a regional exchange, and we hope you found it useful as well. So from my end, thanks again to all the participants. And now I would like to hand it back to Kavya from our Insight Pack team to finish the session. Thanks very much.
Thank you so much.
Thank you.
Thank you.
Thank you.
Thank you. Goodbye.
Thank you.
This
Bye-bye.
concludes session 2, Human Rights Due Diligence and Lessons Learned in ECIS region. We will take a short break and be back at 11 a.m. Central European Time. Thank you. Welcome back, everyone. Thank you again for joining us for the first regional forum on business and human rights in Eastern Europe and Central Asia, making human rights a priority for business. I'm Kavya, and I'll be your technical facilitator today. If you have any questions for the speakers and panelists, please use the Q&A function. If you have any questions about Zoom or require technical assistance, please feel free to privately message Kavya InsightPact for help using the chat box. We will also be providing English and Russian live interpretation throughout the forum. To listen to today's session in Russian, please select the interpretation button on the bottom of your Zoom screen, which is the globe icon, and select Russian. To listen to today's session in English, similarly, please select the interpretation button on the bottom of your Zoom screen, again the globe icon, and select English. I will now pass the floor to Ben Shea, Associate Human Rights Officer, Business and Human Rights, Thematic Engagement, Special Procedures and Right to Development Division at the Office of Human Rights High Commissioner for United Nations High Commissioner for Human Rights, who will be moderating the session titled Improving Accountability and Access to Remedy. Ben, the floor is now all yours.
Thank you, Kavya. And good afternoon, everyone. Thank you for joining this virtual panel on improving accountability and access to remedy. My name is Ben Shea, and I work for the Business and Human Rights Unit at the Office of the High Commissioner for Human Rights. And I'm pleased to be joined today by an excellent panel who will share their experiences facilitating access to remedy through different types of remedial mechanisms in countries throughout Eastern Europe and Central Asia. But before I introduce these experts, I'd like to just set the scene a bit by providing a quick overview of what the guiding principles say about access to remedy and sharing the work my office has been conducting since 2013 on this topic. Kavya, could you please start the presentation I shared and go to the next slide? Thank you. So human rights law has long imposed obligations on states to provide remedies for victims of human rights violations. And the right to a remedy is an essential component of human rights treaties and has been affirmed numerous times by different human rights bodies. Next slide. The importance of right to remedy is emphasized in the guiding principles. So the UNGPs recognize that even with the best policies and practices in place, a company may still cause or contribute to human rights harms that it has not foreseen or been able to prevent. And when this happens, those impacted must have access to remedy. So references to remedy can be found in all pillars of the guiding principles, though the entire third pillar is dedicated to the respective duties of states and responsibilities of companies as regards access to remedy. As for states, the pillar is based on the obligations that they have under existing human rights law to take steps to investigate, punish, and redress abuses in their territory and jurisdiction. And as for companies, when a company has identified it has caused or contributed to human rights harm, it should provide for or cooperate in its remediation through legitimate processes. Next slide, please. So the remediation processes that companies are expected to actively engage in fall into three main categories. So under the guiding principle framework, these are referred to as state-based judicial mechanisms, state-based non-judicial grievance mechanisms, and third, non-state-based grievance mechanisms. And for these second two categories, the guiding principles provide a list of effectiveness criteria that can help states and non-state actors assess how their mechanisms function with respect to human rights standards. So all of these mechanisms have their pros and cons, and they should be seen as different tools that should be used together to help victims obtain remedy. Next slide, please. So in the years following the endorsement of the guiding principles by the Human Rights Council, our office noticed that most attention was focused on implementing the first two pillars of the guiding principles, and not as much attention was being paid to this third but equally important pillar on access to remedy. So our office recognized that for the guiding principle framework to succeed, there would need to be progress made on this third pillar. And in 2013, we began a project aimed at strengthening its implementation. And this project has become to be known as the Accountability and Remedy Project, or ARP for short. So the project's substantive work has proceeded in 3 phases, with each phase requested by the Human Rights Council. And each substantive phase of the project has corresponded to one of the categories of grievance mechanism in the guiding principles. So the first phase, or ARP1, focused on judicial mechanisms. And the second phase, or ARP2, focused on state-based mechanisms other than courts. And the third phase, or ARP3, focused on private grievance mechanisms. And the goal for each of these phases was to enhance the effectiveness of the respective grievance mechanism through the development of guidance on what a good mechanism should look like and what steps should be taken to develop such a mechanism in practice. Next slide. So the guidance for each of 2-year phase of the project was developed through an evidence-based consultative process, during which we tried to learn about the pros and cons of as many systems as possible in as many jurisdictions as possible. And we focused particularly on those who used the mechanisms, those who administered the mechanisms, and practitioners who have experience with the mechanisms, as we wanted to understand the challenges on the ground and find realistic solutions. And in the end, we derived practical recommendations for improving access to remedy that recognize the different legal, cultural, and economic realities that exist in different parts of the globe. So I will expand a bit on each category of mechanism before turning to our panel, who will discuss how these mechanisms work in the region. So in the first phase of our project, we focused on judicial mechanisms, or courts. And the guiding principles recognize that these mechanisms are at the core of ensuring access to remedy. And the guiding principles call on states to reduce legal, practical, and other barriers that could lead to a denial of access to remedy. And in particular, these mechanisms should be free of corruption, be independent of pressures from state and business actors, and ensure the protection of human rights defenders. So our ARP1 work was based on extensive empirical research and consultation with different stakeholders in over 60 jurisdictions. And some of the key findings include that there are significant legal, financial, and practical barriers to accessing remedy in all jurisdictions, and no jurisdiction is doing a particularly well job at addressing them. Domestic legal regimes are failing to keep up with the complexity of business enterprises. Typically, prosecutors need more political and financial support, and there is scope for much improvement in liaison and communication between different state agencies in cross-border cases. Next slide, please. So the second phase of our project, or ARP2, focused on state-based institutions other than courts. And this category includes a very wide range of mechanisms, such as national human rights institutions, the OECD national contact points, and labor inspectorates, just to name a few. And these types of mechanisms play an essential role in complementing and supplementing judicial mechanisms. Judicial remedy is not always required, and nor is it always the favored approach of rights holders. For ARP2, we looked at hundreds of these mechanisms across dozens of jurisdictions. And some of the key findings from that piece of work include that these mechanisms offer a number of advantages over judicial mechanisms in terms of accessibility, especially with respect to legal costs and the types of remedies that may be given. However, overall coverage tends to be patchy and piecemeal. Very often, these types of mechanisms are designed to address a particular problem. So there's insufficient attention to the wider regulatory context. But at the same time, these mechanisms make important contributions to the wider package of remedies. And by assessing these kinds of mechanisms only by reference to what they can do on their own, we overlook their real value and potential. Next slide, please. And finally, the third phase of our project, or ARP3, focused on the effectiveness of non-state-based grievance mechanisms. And many different mechanisms fall into this category, including operational level grievance mechanisms of companies, mechanisms of multi-stakeholder initiatives, and independent accountability mechanisms of development finance institutions. And the guiding principles recognize potential benefits of these mechanisms, such as speed of access and remediation, reduced costs, and transnational reach. With respect to companies' operational level grievance mechanisms in particular, the guiding principles highlight their role in aiding in prevention efforts, greatly reducing the risk of harm to people, as well as liabilities for the company. So these mechanisms help companies identify human rights harms and address such harms early and directly, thereby preventing harms from compounding and grievances from escalating. So there is a strong business case for having effective grievance mechanisms in place, taking grievances seriously, and providing remedy early. It prevents major issues down the road, thereby managing operational, legal, and reputational risks. So our ARP3 report was presented this year to the Human Rights Council. Some of the key headlines include that few of these mechanisms are reaching their potential. Rights holders tend to report problems identifying, accessing, and using these mechanisms in practice. Eligibility and procedural requirements are often overly complex, necessitating the assistance of lawyers or civil society. And any remedies obtained are usually partial at best. Secondly, we found that the most effective mechanisms are those that meaningfully consult with the people for whose use the mechanisms are intended. So generally speaking, grievance mechanisms need to give much greater emphasis to the needs, expectations, and perspectives of rights holders, both with respect to the design of mechanisms and the outcomes in specific cases. And as regards the role of the state, we found that there is a lack of policy coherence in their approaches to these types of mechanisms, which makes it harder for them to reach their potential. Thus, there is a need for greater recognition by states of the legitimacy and utility of non-state-based mechanisms. Next slide, please. So while these key findings from all phases of the project can be found in our reports, I'd like to stress that each report actually focuses on evidence-based solutions. So each report contains a series of recommended objectives to be obtained, and these are complemented by numerous good practice examples for how to achieve these objectives in practice. And finally, I'd like to mention that our office is beginning work on a new fourth phase of the project, which is focused on enhancing the accessibility and implementation of all of the findings we've developed over the past 6 years of the project. Thus, we hope to increase engagement with states, business, and civil society going forward in order to put our findings into practice. So with that overview, I'd like to turn it over to our brilliant panel of practitioners to share their insights on the different kinds of grievance mechanisms available in the region. We are fortunate to have with us experts who can speak to each category of mechanism outlined in the guiding principles. First, we will turn to Tatiana Zinovich. Tatiana is the head of the Legal Policy Research Center in Kazakhstan, which is a think tank specializing in responsible business conduct, rule of law, transparency and accountability, as well as human rights and security issues. She is an expert in the field of responsible business conduct with 15 years of experience in NGOs. And she helped organize the first summer school on responsible business last year in Kazakhstan. And she is a member of the OECD National Contact Point of Kazakhstan. So Tatiana, you have the floor.
Thank you, Mr. Moderator. I'm very happy to be a part of such important event. And since my English is not so good, my speaking will be in Russian. Я бы хотела остановиться как раз на тех компонентах, которые были озвучены в предыдущем выступлении, и рассказать о том, как это работает на примере Казахстана. Но я думаю, что пример Казахстана, он будет очень ярким и будет как бы транслировать тот опыт, который мы можем проследить и в других странах Центральной Азии, потому что по уровню экономического развития мы продвинулись достаточно хорошо среди стран Центральной Азии и по уровню бизнеса, и по уровню государственных каких-то инициатив. Поэтому я думаю, что те заметки, которые я сегодня озвучу, они в равной степени в каком-то смысле будут относиться и к опыту многих других стран нашего региона. В отношении вопросов, связанных с такими механизмами, как судебная защита, здесь важно понимать, что в Казахстане предусмотрена защита на уровне Конституции, что граждане имеют право обращаться в суды национальные. И в этой части мы видим очень богатый опыт у судебной системы, потому что в Казахстане очень много исков ежегодно поступает в рамках гражданского судопроизводства. И здесь мы видим, что, с одной стороны, население доверяет судебной системе и в каком-то смысле стремится на уровне иска защищать свои права, но с другой стороны мы наблюдаем, что сама судебная система не вполне дает тот уровень защиты, который необходим. В частности, вот господин модератор упоминал такие компоненты, как независимость и свобода от коррупции. В этой части нам нечем похвастаться, потому что у нас уже много раз Казахстан получал рекомендации со стороны международных органов в отношении укрепления независимости судебной системы. И пока эти вопросы не нашли своего разрешения, судебная система все еще зависит от исполнительной власти. И мы видим, что очень часто суды становятся своеобразным источником коррупционных скандалов. И в этом смысле у Казахстана есть тоже ряд рекомендаций со стороны, например, Организации экономического сотрудничества и развития, которая дала многочисленные рекомендации по укреплению судебной системы в вопросах антикоррупции и вопросах добропорядочности. И очень много рекомендаций было высказано со стороны ОСР в рамках Стамбульского плана действий против коррупции, участником которой Казахстан является. Вот. С другой стороны, мы видим попытки судебной системы каким-то образом усилить доверие граждан. И мы даже видим, что Верховный суд инициирует социологические различные опросы, чтобы замерить уровень доверия со стороны населения. Но пока эти результаты не очень нас радуют. И я думаю, что в этом направлении есть над чем еще работать государству. А с другой стороны, мы видим, как государство стремится развивать различные внесудебные институты по защите прав. Один из таких институтов – это медиация. И сейчас сферой применения медиации в Казахстане являются споры, которые возникают из гражданских, трудовых и семейных и других правоотношений, как с участием физических, так и с участием юридических лиц. И сейчас процедура медиации не применяется к спорам, которые возникают из вот этих отношений, если такие споры затрагивают или могут затронуть интересы третьих лиц, например, или интересы государства, государственных органов. Поэтому медиация существует в двух видах. Это профессиональная независимая медиация и судебная медиация. Но, к сожалению, вот замерить их эффективность мы сейчас не можем, потому что практически никак не аккумулируется статистика. И нам очень сложно узнать, как активно граждане используют этот институт в той части, которая касается именно защиты прав, затрагиваемых со стороны бизнеса. Отдельно существует институт согласительных комиссий на предприятиях, в различных организациях. Они работают по индивидуальным трудовым спорам между работниками и работодателями. Но этот институт больше работает на каких-то крупных предприятиях, субъектах крупного бизнеса, может быть, среднего. Но когда речь идет о малом бизнесе, индивидуальном предпринимательстве, там этот институт, естественно, не развит. Отдельно внимание обращать на себя это то, что происходит с профсоюзами и профсоюзной деятельностью в нашей стране. Уже, наверное, многие слышали, что Федерацию профсоюзов Казахстана исключили из Международной конфедерации профсоюзов. Такое решение приняли участники 4-го конгресса Международной конфедерации профсоюзов, и которые лишили делегацию Казахстана полномочий, приостановили членство наше в этом объединении по причине полной утраты независимости. Вот. И в качестве объяснения было высказано, что обоснованием послужило, что полная потеря независимости от властных структур профсоюзов в Казахстане, и в результате чего казахстанское объединение профсоюзов сейчас возглавляют бывшие чиновники, которые, с одной стороны, содействовали ликвидации независимых профсоюзов. За несколько последних лет у нас была реформа профсоюзной деятельности, и все профсоюзы были вынуждены проходить перерегистрацию. Независимые профсоюзы эту перерегистрацию не прошли. Была создана такая пирамидальная постсоветская система профсоюзной деятельности, своеобразной подведомственности и иерархии нижних профсоюзов перед верхними. Вот. И несколько профсоюзов были ликвидированы, а после протестов со стороны независимых профсоюзных активистов многие из них оказались за решеткой. Вот. И то есть здесь тоже мы не можем похвастаться, потому что мы видим, что не всегда трудовые коллективы находят защиту перед своим работодателем. Отдельно действует в Казахстане институт омбудсмена, полномоченный по правам человека. Туда также люди обращаются в результате каких-либо жалоб, в том числе жалоб, связанных с нарушением прав в рамках предпринимательской деятельности. Но опять же мы знаем, что институт омбудсмена в Казахстане не соответствует парижским принципам, и поэтому тоже очень сложно говорить, что это является эффективным инструментом по защите прав. Есть институты омбудсмена, которые создаются самими организациями, И в основном эта практика распространена в субъектах крупного бизнеса и в квазигосударственном секторе очень развита. Такие омбудсмены создаются обычно собранием акционеров, выбираются советом директоров либо правлением и направлены на усиление мер по предотвращению и регулированию трудовых споров, конфликтов, улучшение имиджа этих организаций, предприятий и в то же время совершенствование системы корпоративной культуры, деловой этики. Сейчас также мы видим, что компании активно развивают комплаенс-службы, включая антикоррупционный комплаенс, и государство со своей стороны принимает усилия по регуляции института whistleblowers, но, опять же, пока мы в законодательстве не видим четкого регулирования по этим вопросам. Недавно, буквально в сентябре, премьер-министр на заседании правительства поручил Министерству торговли и интеграции совместно с нашей национальной палатой, это МИКЕН. Это большая палата, такой своеобразный квазиорган, который должен представлять интересы всех предпринимателей Казахстана. Поручил создать институт омбудсмена на базе неправительственных организаций, который будет заниматься защитой прав потребителей. И вот ожидается, что к концу года должны будут приняты меры в отношении создания такого омбудсмена. Отдельно действует национальный контактный пункт. Он создан при Министерстве национальной экономики. В этом году национальный контактный пункт занимался тем, что разрабатывал свои положения, регламенты и правила по рассмотрению жалоб. Пока никаких жалоб рассмотрено этим национальным контактным пунктом не было. Но я напомню, что этот орган создается в рамках руководящих принципов ОСР. И Казахстан получал несколько рекомендаций и по поводу совершенствования работы национального контактного пункта. Сейчас туда входят представители отдельных министерств, представители профсоюзов и несколько представителей гражданского общества, как члены национального контактного пункта. И вот мы ожидаем, что в ближайшее время он тоже сможет заработать. Вот, поэтому в любом случае мы видим, что со своей стороны государство и бизнес какие-то попытки предпринимает, но с нашей точки зрения они не являются достаточными для того уровня экономического развития, для того большого рынка труда, который в Казахстане существует. И мы надеемся, что ту работу, которую проводят наши коллеги, создают такие замечательные руководства, мы сможем использовать для того, чтобы вести диалог с властью и нацелить усилия на улучшение ситуации по защите прав в рамках предпринимательской деятельности в Казахстане. Спасибо большое.
Thank you so much, Tatiana. That was very useful and enlightening. Definitely some challenges that are being dealt with in Kazakhstan, particularly with respect to the trade unions. In our last, well, basically in all phases of our work, of the Accountability and Remedy Project, we had a specific focus on instances of retaliation and how simply retaliating against trade union leaders or people raising grievances doesn't resolve any issues. It just kind of delays things. And it's interesting to hear about the new developments that are going forward. And yeah, I think it would be interesting to hear your thoughts on what opportunities exist to increase access to remedy in the near term, and we can get into that in the Q&A. I'm getting personally Russian interpretation on the English channel right now, which is a little distracting. So hopefully that can be resolved going forward. But now I think we'll turn to our second panelist, who's Anna Dengova-Hug. Anna is a co-founder of Interpartes Skopje, a leading law firm in North Macedonia. that provides legal services to clients regarding the guiding principles on business and human rights. Over her career, she has designed and delivered various trainings on human rights for lawyers, prosecutors, judges, and human rights practitioners. She has helped produce multiple publications on business and human rights, including a recently published tool on children's right to health in business. Anna, you have the floor.
Thank you, Ben. Thank you very nice for the nice introduction. First of all, it's a great pleasure to be here. I think this is a great event to change ideas and experience on this topic, which tackles this part of the region. So I would like to speak a little bit about success, challenges, and opportunities regarding remedy through judicial mechanisms. But before I digging into this topic, I would like to give a sort of a snapshot of the legal regime of this topic in North Macedonia, but also enlarge it to the other part of this region and speak or refer to the legal regimes of other non-European Union or Western Balkan countries, and those being Albania, Bosnia-Herzegovina, Kosovo, Serbia, and Montenegro. So what is very common about all of these 6 countries is that none of them have introduced or are intending to introduce mandatory human rights due diligence regimes in general or topic specific. And also what is lacking is a corporate human rights reporting regime. So overall, the only recourse available for victims is that offered by the civil or penal procedures. However, the penal system is not drafted with the human rights language. 4 of these countries, so Albania, Montenegro, Kosovo, and Serbia, have enacted a separate law on criminal liabilities of legal entities. And in my view, the Montenegrin law is the most advanced one because it establishes the due diligence standard as an expected behavior for companies. Therefore, for example, if an accused legal entity can show that they have taken all effective, necessary, and reasonable measures in order to detect and prevent crimes, and also encourage employees to act in accordance with the law, then most probably this legal entity will be liberated from the criminal charge. Also, what is common is that these laws do not directly regulate the situation where a crime is committed. So in some, a foreign company is criminally liable because of complicity with the subsidiary in all of the 6 countries, and we operate within the general conditions of criminal liability for foreign companies. As far as the private law claims are concerned, again, here there is no specific civil regimes designed for human rights abuses, and therefore we as lawyers, we operate by using the general tort law principles, and we need to prove either intent or negligence. So in sum, this is in a nutshell, the legal regimes in all of these countries, they are very similar, and I think this is part of due to the history of this region. So when we speak about opportunities and successes for lawyers, I think that even within this, let's say, framework or context, lawyers can be very creative and frame their orders or criminal charges with the human rights language. The hard law and soft laws are always there to refer to. However, this is not always accepted by judges, as it is considered as a very novel approach. For example, in 2019, as a part of a strategic litigation, we had drafted an order against the state organs, so the government, the Ministry of Environment, and the town of Skopje, asking the court to rule that the state has violated the right to health, the right to environment, and the right to privacy of the plaintiff because they have not fulfilled their obligations So even if this case is not directed to against the private sector, we have a lot of materials which proves that the state has failed to send inspectors on the spot to check how are the factories working when it comes to being compliant with their obligations concerning the air pollution, and more specifically PM10 and PM2.5. Air pollution is a huge problem in North Macedonia, and I think that it's very similar in the other parts of the region. And concerning challenges, I will name two. So the first being, it's very evident from the legislation and also from the curriculum of Academy for judges and prosecutors, that there is a lack of knowledge of the main concepts regarding business and human rights. So the victim has a burden of proof in two directions. Firstly, we need to, in the courtroom, we need to familiarize the judges with all the necessary, all the existing standards on business and human rights, and then we proceed with proving a criminal or civil liability of the opposing party. And the other challenge is more on a policy level. What is evident from the European Union reports that all of these 6 countries are sending to the European Commission is that the topic of business and human rights is non-existing. So, and there is no obligation to report neither on the European Union non-financial directive. And I know that these countries are not yet a member of the European Union. However, I think it will be, it should be a requirement, because in North Macedonia, but also in the other countries, there are a lot of subsidiaries and companies who are part of the supply chain of European Union-based businesses. And therefore, for us as lawyers, it will be extremely helpful if we can use these reports to rely on in order to demonstrate the failure of the state in establishing effective regulatory regime for preventing corporate-related human rights abuses. So overall, in my opinion, there's a lot that needs to be done in the level of legislation, but also training and capacity buildings for judges, prosecutors, and lawyers if you want to advance this topic in this part of the region. So thank you, Ben. Now the floor is yours.
Thank you, Anna, for the overview of the kind of legal regimes in the region, some opportunities and some challenges. I think, for instance, to be really well versed in business and human rights, but there, you know, there's opportunities there to train the judiciary, or, you know, have conversations like this. So I think it's really important that this forum's taking place to kind of raise visibility of these issues. So now we'll turn to Dirk Hoffman, who is a senior advisor at the Danish Institute for Human Rights, with a background in international human rights and labor law. Dirk has more than a decade's worth of experience working with business, government, and civil society on business and human rights topics in various country contexts. Dirk has supported both states and civil society on national action plan processes in different countries in the region, including in Ukraine, Georgia, and Serbia. So Dirk, you have the floor.
Thank you, Ben. I have prepared a little presentation as well. Let me first say I really appreciate being here, and congratulations on this event. I think it's really wonderful to see that the spotlight is shown onto this region, which I think has been to a degree neglected for quite a while on this this topic. I've done my very best to sedate all children and tie up all dogs that I have, but you may hear some whining in the background. I hope you can excuse that. So I'm speaking on behalf of the Danish Institute, but I'm also representing ENRI, which is the European Network of NHRIs. You can actually go to the next slide already. So I just wanted to say a few words for those of you who may not be familiar with what a National Human Rights Institution or an NHRI is and what ENRI is. So most countries have a National Human Rights Institution. Some of you will be familiar with ombudspersons or public defenders or other types of names that are being used for a similar institution. And they usually have the duty to advise the state on human rights issues. And as the Edinburgh Declaration made clear, NHRIs also have a role to play when on business and human rights. And the ENRI network, or specifically the European Network of NHRIs, has a working group on business and human rights as well that has been connecting NHRIs across Europe on this topic. We bring together more than 40 national human rights institutions across Europe, and human rights in business is one of the key topics that we are working on. You can go to the next slide. So I'm here to share with you the results of a research that our institute undertook that looked a little bit at what roles NHRIs are currently playing on access to remedy in regards to business and human rights cases. It's a global research, so it doesn't just focus on this region, but it also includes the answers or results from NHRIs, for example, in Albania, Armenia, Azerbaijan, Georgia, Poland, Serbia, Slovenia, and Slovakia from this region, but also NHRIs from the Asia-Pacific region and others. The report has two parts. One is basically based on a questionnaire that was shared with more than 30 NHRIs, or 33 that have responded. That's the part that I'm going to focus on. And it also comes with policy recommendations for national human rights institutions on how, and also for states, how this function of NHRIs in regards to access to remedy can actually be improved in the future. The second part focuses on 4 case studies that are all located in the African region. So I recommend, if you're interested, check it out. At the moment, the executive summary and the policy recommendations are available in English, French, and Spanish. And I think that's a little bit lacking for the region. It would be good if we can add at least Russian to make it more widely accessible, but I'm hoping that you find a language that you understand. Next slide, please. So with this research, what we try to do is identify common challenges that are faced by national human rights institutions and how these can be addressed to strengthen the capacity of NHRIs to enhance access to remedy for victims of business-related human rights abuses. So that's why we produced this research. We hope it's also can be used in kind of advocacy. There are at country level national action plans going on in some of your countries that you may be familiar with. That's of course also an opportunity, for example, to take up some of these policy recommendations and strengthen the roles that NHRIs play in your local context. So we looked at these 10 listed areas that you see listed here. I want to very briefly say something about all 10 of them. And I'm trying to stick to time, but please remind me if I'm going over time. I'm really doing my best. It's going to be brief, but I recommend you read the report for more details. So in general, what the research found in regards to the mandate and the capacity and resources of NHRIs on business and human rights, it found that a lot of NHRIs already work on access to remedy in business and human rights cases. And ideally, they have a legal mandate that actually allows such work and also assigns resources, including financial and staff capacity. But this was also noted as an obstacle to a lot of NHRIs, that they actually did not have a designated or called out mandate to work on business and human rights related cases. On the topic of complaints handling specifically, we found that having a complaints handling function can facilitate important contributions to access to remedy, but that NHRIs had very different mandates for the types of complaints that they can address. And interestingly enough, it was especially European NHRIs that lacked complaints handling mechanisms or lacked the mandate to address business and human rights related cases. Overall, there's a lack of data on business-related complaints received by human rights institutions, and this is also not systematically collected or analyzed, and that's definitely an important area for further development and research in the future. In regards to alternative dispute resolution, which is kind of the second area of what the guiding principles say when they talk about non-judicial grievance mechanisms, this is a key way that NHRIs often apply a mediation or conciliation role rather than an adversarial role. And these processes have a potential to build understanding between parties and generate solutions or resolutions that are agreeable to both parties. But on the other hand, the research has also cautioned that NHRI's application of alternative dispute resolutions must not undermine the state's duty to investigate allegations of serious violations of human rights. And it may also pose serious limitations in terms of addressing root causes and building legal precedent. On the topic of enforceability of remedies, most human rights institutions that responded to the questionnaire indicated they can only offer non-legally binding remedies. And while we, of course, shouldn't underestimate the effects of making recommendations or providing legal aid or releasing public statements, these limited enforcement powers do pose a significant risk to rights holders who may be subject to a less timely or more drawn out remedy process that in the end could prove to be quite ineffective. We also looked at common strategies that NHRIs took to enhance gender responsiveness and accessibility for particularly vulnerable rights holders. And here we noted that NHRIs, for example, have regional offices in place to make them more accessible to people in the countryside. They conduct specific information outreach to vulnerable rights holder groups, or they provide language and logistical assistance to facilitate accessibility. However, it needs to be noted that NHRIs typically don't have their own mechanisms to protect people who are at risk of threats or of intimidation because of their complaints, so they can only contact law enforcement agencies in this case. Public inquiries were highlighted as by numerous national human rights institutions who responded as being a very relevant instrument in the field of business and human rights due to their public nature. The downside of those are that they are usually extremely time and resource intensive, and frequently national human rights institutions struggle with undertaking consistent monitoring and follow-up on recommendations that were made after a public inquiry. Aside from the immediately very relevant complaints handling and the investigations and public inquiry functions, NHRIs also have a number of other strategies of indirectly facilitating access to remedy. So examples that were shared included, for example, awareness raising and capacity building of different actors, influencing policy and legislation, research, of course, monitoring and compliance, and also activities facing business actors directly. It was highlighted that collaboration with other actors and mechanisms is particularly important and can take a range of forms. For example, judicial and other remedial mechanisms such as multi-stakeholder mechanisms or national contact points, operational level grievance mechanisms at company level. Or other actors at the national level, such as state, civil society, and business actors that NHRIs could collaborate with. And as I mentioned, it's also important that NHRIs collaborate with each other and learn from each other's experience. So NHRI networks like ENRI, but also exist in other regions, have proven to be quite important. And last but not least, regional and international human rights mechanisms. And then lastly, on the topic of extraterritoriality and cross-border cases, this is clearly an area that is underdeveloped at the moment. Most NHRIs in the world do not have a mandate that allows them to address abuses outside of their territory, even though the Paris principles do state that NHRIs have a responsibility of cooperating with regional institutions and the national institutions of other countries. Despite this, some NHRIs included in the study demonstrated innovative application of their mandate already to tackle such issues. So there were examples from the NHRIs in Malaysia and Indonesia that have collaborated in resolving complaints. So you can go to the next slide. As I mentioned, in relation to all of these areas, we try to come up with policy recommendations that actually improve how NHRIs are facilitating access to remedy. I just want to highlight some of them. There were way more, of course, but some of the areas that were highlighted were that the NHRI mandate should be broad and explicitly permitting and encouraging work on business and human rights. And it's also important that capacity building is conducted for NHRIs, and dedicated resources for business and human rights is allocated. Where NHRIs have a complaints handling function, this should include the ability to address business and human rights related complaints explicitly. And it would be very, very good if NHRIs also kept statistics and analyzed patterns and trends of cases that they receive. Measures to strengthen the enforceability of remedies is clearly like an area that needs to be improved. This could be done, for example, by providing enhanced implementation for recommendations. NHRI should also apply their investigation and public inquiry powers to address especially systemic business and human rights issues that are not like single cases, but actually are widespread issues in the country. And last but not least, I want to highlight that NHRI should apply the full range of their Paris Principles mandate to contribute to business and human rights in a very holistic manner, including through collaboration with relevant actors. That concludes my presentation. I hope I stuck to time. So Ben, back to you, and thank you for your attention.
Thank you, Dirk, for this very good and comprehensive overview of the role of NHRIs in business and human rights cases. Yeah, your findings agree a lot with what we found. Definitely, there are difficulties, you know, coming up with broad, overarching findings when NHRIs have very different mandates. But it's good that you highlighted some of the more creative ways in which NHRIs can and have been using their mandates to indirectly facilitate access to remedy. And we can explore that a bit more in the Q&A section. Just to remind everybody, there is a question and answer box at the bottom that you can write questions for the panel. And we will be turning to that after our next two speakers. So our next speaker is Tamar Gvarmatzi. I apologize for likely mispronouncing your name. Dirk just gave an overview of kind of the NHRIs in general in the region and in the world. And Tamar can give a closer insight into a specific NHRI, that of Georgia. So Tamar is the Deputy Public Defender of Georgia's NHRI since 2018. She's a legal professional with over 11 years of experience in both managerial and administrative positions in both the public and non-governmental sectors. She has a PhD in law, is an associate professor of law at Tbilisi State University, and is a board member of the European Human Rights Advocacy Center and Georgian Young Lawyers Association. So Tamar, you have the floor.
Thank you very much. Thanks for introduction, and good morning and good afternoon, ladies and gentlemen from different time zones. Greetings from Georgia. First of all, I'm very, very glad to have an opportunity to participate in this very interesting session, and would like to express my gratitude to organizers for the invitation. Let me share Georgian experience of preventing business-related human rights abuses by the Ombuds Institution. As you mentioned, I represent the Office of the Public Defender of Georgia, which is an institution with multiple functions. We operate as a typical ombuds institution, examining cases of maladministration based on complaints or own initiative. We're a quality body. We're at the same time national preventative mechanism and also responsible for the monitoring of convention regarding people with disability. Moreover, we hold A status as an NHRI institution in full compliance with Paris principles. So you can observe that we deal with many functions. In our legal system, judicial mechanisms and courts are the core institutions for ensuring access to remedy in business-related human rights cases. When it comes to public defender and our office, it is just a state-based, non-judicial grievance mechanisms with a limited mandate comparing to courts, but I think, and comparing to many other institutions and our partners, we are quite effective. So, based on our legal framework, we can facilitate access to remedy both directly by handling complaints concerning business-related abuses and indirectly by monitoring, conducting capacity building, raising awareness, assisting affected right holders, and recommending legal reforms. Particularly under our general mandate, our office investigates the facts of human rights violations related to decisions and actions of private companies which provide public services. Moreover, we study the applications from the individuals regarding the effectiveness of responses provided by the state institutions in case of business-related human rights violations, as well as guarantees prescribed under legislation to prevent such incidents or to ensure to access to effective remedy. For example, when it comes to the violation of regulations concerning the occupational safety at workplaces in different companies, our institution does not have direct mandate to intervene or to examine the case, but we can apply to the state institution responsible for the monitoring such cases and evaluate effectiveness of these state institutions. As I mentioned, one of our functions is promoting equality in the country, and since 2014, we are functioning as a quality body. Under this mandate, differ from our general mandate as an equality body, we are authorized to deal directly with complaints against private companies, even those which are not delivering any public services and which are purely private by their nature. Also, in this capacity, which is also very, very effective part of our mandate, our recommendations are binding for them. And we can refer to the national courts and demand the enforcement of the recommendations addressed to private entities if they are not fulfilling them. We don't have such power under our general mandate, and we can't do it, for example, when we deal with typical cases of maladministration, and our recommendations in those directions addressed to public entities are not binding for them. It is just recommendations. But when it comes to equality body and the recommendations addressed to private sector and private companies, these recommendations are binding for them. We're also dealing with private companies under MPM mandate. As I mentioned, we are national preventative mechanism, and as such mechanism, we are systematically monitoring different types of closed institutions. Some of them are under the management of private organizations, for example, psychiatric institutions, daycare centers for elderly, small group homes for children. And as a CRPD monitoring mechanism, we also systematically conduct monitoring with these two daycare centers for persons with disability as well. While performing our different mandates, of course, we identify challenges, but have some success stories to share as well. I can mention our recent cooperation with one of the psychiatric institutions, accepting our recommendations regarding infrastructure and rebuilding several facilities. And this psychiatric institution is run by the private company. Also, some cases of sharing different recommendations by companies and elaborating their policy regulations related to gender equality can be also mentioned as a successful stories of our activities and our work. While working with the private sector, we try time to time to apply and explore our mandate to new directions. For example, last year we conducted really for the very first time the monitoring of our of a primary health care program, which in some municipalities of the country are run by the private entities. And it was really very important monitoring, and the results were very valuable for us and for the private sector, and also for the state and responsible ministry. Also, the very latest positive development I would like to share is related to strengthening of our mandate in new legislation, enabling our institution to examine cases against private companies functioning in the field of child's rights. And we're looking forward to explore and strengthen our activity in that direction in the nearest future. When it comes to our work on the policy level and promoting legal reforms related to business and human rights, I would like to mention that in Georgia, we do not have a special separate action plan related to business and human rights, but it is a part of the general human rights action plan. There is a special chapter in the document which identifies different activities and relevant institutions responsible for their implementation. And we try to follow and monitor the implementation process of the action plan and call on different state institutions and stakeholders about the problems in this implementation problem and provide our recommendations. We're also involved in the process of drafting new human rights strategy of the country, which started this year. We submitted our general opinion regarding different topics, including business and human rights, during the first round of the consultation process, and will continue to cooperate with the government of Georgia in that regard in the future. We also work on the business and human rights issues with our international partners. We are involved in the work of the working group of the European network of NHRIs. ENRI has been actively following developments in UN open-ended intergovernmental working group on transnational corporations and other business enterprises with respect to human rights since its establishment, and provided with very valuable recommendations to different stakeholders. Our office is also participates in different international events related to this topic. For example, last week, you may know that there was a huge forum of UN Human Rights Council's high-level forum regarding business and human rights, and we also, we were involved in this forum and shared our experience. Finally, I would like to say a few words about our work during the COVID-19 crisis and how we deal with this business-related human rights during this period. Besides lockdown in spring and some limitations currently set by the state, we continue working. We made significant changes in our methodology, set security rules for staff, and adapted to distance and online work format. During lockdown, special quarantine spaces have been created for the mandatory placement of the relevant persons to prevent the spread of novel coronavirus. And all these special quarantine zones were run and actually by different private companies. Actually, these were spaces of hotels, different hotels throughout the country. So our office started examining conditions in these quarantine spaces and monitored the overall human rights situation in the country. We still work distantly, although office continues to receive applications from citizens online or by post and conduct monitoring to different institutions if needed. It is also noteworthy that an awareness-raising activities of the office started online discussions on human rights, which are broadcasted usually live via our Facebook page. During this period also, we intensified non-formal communication with different private companies. We used so-called approach, naming and shaming, in order to somehow affect directly or sometimes indirectly on the activities and decisions of some private companies. And we thought that it was much more effective rather than to initiate formal proceedings or formal kind of stages against such companies. So hope this short introduction about our work was interesting. And in case of questions, I would be more than happy to answer and share more detailed information about our office during the discussions. Thank you very much for your attention. Thank you.
Thank you, Samar, for that comprehensive overview of the many and varied roles of the Georgian NHRI. Yeah, there's a lot that you're taking care of, and it's really impressive the amount of different things you're working on, different ways to have handle direct complaints, but also the indirect ways in which you facilitate access to remedy and kind of the connections with other mechanisms like courts and examining how they are handling cases, and in other ways that you're creatively using your mandate. I think now we'll be switching gears from the state institutions to the private space. And to do this, we are joined by Marina E., who is the head of Social Performance Division at Sakhalin Energy. Marina has over 17 years of experience working on responsible business conduct, focusing on social impact assessment and monitoring, human rights, grievance mechanisms, and non-financial reporting. Prior to joining Sakhalin, she was a lecturer in statistics and labor sociology. And we are very grateful to have Marina join us, particularly as she volunteered to replace her colleague's spot just this morning. So thank you very much for the willingness to join our panel, and you now have the floor.
Hello, dear colleagues. First of all, thank you organizers for this great opportunity to be here and to hear such great experience from different parts of our region. Several words about Sakhalin Energy Investment Company Ltd, or Sakhalin Energy, to see why human rights agenda and in particular remedial measures is our priority. Sakhalin Energy is the oil and gas company that operates one of the largest oil and gas projects, Sakhalin-2 project, title of this project. We locate on Sakhalin Island. This is the Russian Far East, and the hundreds and second-tier contractors, with around 25,000 people of multinational background were involved during construction and 10,000 people during operation phase. Major construction is over, but the project is still expanding. Planned project activities have yet to engage about 3,000 people. So certainly of such complex projects, especially through supply chain, has a great potential for positive social footprint. But on the other hand, if poorly managed, the human rights risk could become a source of adverse impacts, like supply chain risk, community impacts, labor rights, and so on. That is why Sakhalin Energy regards human rights due diligence, including in supply chain, is a vital part of the company's social responsibility. So since the main plot of the panel is about grievance mechanism, let me tell a bit about corporate experience based on our Sakhalin Energy company in this area. At the times we first developed our grievance procedure, and it was in 2002, there were no specific international standards for addressing grievances at the corporate level. So that time we relied on the best practices that were applied by business for grievance addressing. And also we took, of course, into consideration conclusions of impact assessment and our engagement strategy approach. Since then, our procedure has undergone several updates based on our experience and emerging international standards, including guiding principles. In order to effectively address grievances raised in connection with our project, the company adopted grievance mechanism for own personnel and for external stakeholders. Our procedure are based on the guiding principles, especially that we were one of the 5 companies worldwide selected for testing the principles related to corporate grievance mechanism. And later, we participated in the development of the oil and gas sector guide on implementing the principles. So, as of today, we operate grievance mechanisms about 18 years. And today, I would like to share from our side with practical tools for effective implementation, then key challenges to focus on, and then what advantages that we get from implementation of the grievance procedure. So advantages or benefits for business to implement remedial measures. Important practical tools for effective grievance mechanism. I would highlight 4 of them. First of all, the grievance addressing mechanism shall be not a standalone initiative in the company. It shall be part of whole business management process. For example, our grievance mechanisms have been incorporated into our management system and the higher level policies like human rights policy, sustainable development policy, or code of conduct. And then we have special procedures to implement remedial measures. The progress of grievance addressing is under control by high management of the company. The second practical tool is to be mentioned is clear and in-best mechanism for registration, assessment, and tracking of the grievances to be transparent, the process to be transparent. Also, it is important to have a clear risk assessment tool. For example, Sakhalin Energy applies a special risk assessment matrix for assessment any grievance and proper rating of grievance. And the fourth important practical tool is that contractors should comply with the requirements for grievance addressing. And I would say that there's a critical practical condition in case that, if company act as operator like our company. So in this practical tool, we incorporate relevant requirements into contracts. Then the grievance procedure is included in the regular trainings, including induction trainings, so for all newcomers of our project. And then we monitor how contractors deal with the grievance process. So this is about important practical tools. About key challenges to focus on. I would highlight 2 of them. Challenges to maintain trust and transparency. So it's to ensure that people come to company to share with their concerns. The whole issue of building trust is connected with effective engagement. And this is a critical condition. Engagement in relation with grievance mechanism, we differ into several components. To create sufficient number channels, support help company to address concerns to the company. While we pay special attention to sufficient number of channels, it is common for Russia that community does not brings its concerns to the company because first people did not believe that that business will address their concerns, and the second, people are not aware of the channels through which they can communicate their concerns. So that's why we in the beginning of our project try to see or to find where come people with their concerns, and we found that people used to apply to, for example, local administrations. Therefore, for us, 2 tasks have become very important. First, to raise awareness about about the procedure and ensure sufficient channels. Here, the company initiates regular systematic information campaigns. For example, publications that time many years ago in local newspapers, distribution brochures about the procedure. Then we became more creative, calendars or pockets or posters in different public places. And all these materials also available on our website. Special category here, contractors. During the whole projects, many our materials have been printed or translated in different languages, Russian, English, Japanese, Korean, Turkish, taking into consideration the background of our workforce, so who was engaged into the project. To provide sufficient channels to bring concerns to the company, we use any channels that could be sufficient for potential complaints, like letter, email, hotline, websites or electronic form, community liaison officer, information centers. The company established 23 information centers across the Sakhalin Island. Another component to maintain trust or engagement is regular communication with those who lodge grievances. And this is not about formal letters. This is about two-way negotiations and follow-up monitoring. In addition, we use regular public consultations to promote our grievance procedure, public meetings, focus meetings, and also we use independent public opinion survey to see how our grievance addressing measures effective or not, or whether there are any gaps or areas for improvement. The third point to maintain trust that families or people in settlements with difficult access to see information about grievance procedure, or indigenous peoples, and so on. And the fourth point to trust, to main trust is that could contribute to trust, participation of third-party experts in resolution of some grievances. It demonstrates that to stakeholders that the grievance procedure unbiased. The second challenge for us, and we would recommend to pay special attention to it, is maintain and rise transparency. For us, critical that people know about our to be clear with time frame during the resolution process. All the complainants are made informed on this time frames. Also, this information is publicly available. Besides the continuous communication with the complaints, consultations about potential ways for resolution and expected outcomes. So to make whole process clear and transparent. One of the key components of transparency is our external reporting. And it is also linked to trust. So we discuss with the public, with community during, for example, public meetings, grievance procedure, how to work, then what results, how we address these results, for example, in like proactive measures to avoid such grievances. Also, we include information about grievance addressing in our and outstanding issues as well into our sustainable development report and special report, public consultation and disclosure report. However, transparency should be like stricted we should keep confidentiality because respect human rights should consider this point. And the confidentiality is mandatory part of the grievance procedure, and we make all our best to address anonymous grievances as well. To summarize benefits for business for operating grievance procedure. Of course, and it is maybe the most important, creating trust of stakeholders, obtaining license to operate. Also, there are business benefits like reduction of interest rates when the negotiations loan, or reduction potential costs that may result from legal actions, minimizing legal and reputational risks which may lead to unplanned expenses and delays in work. And also continuous improvement, because grievances demonstrates gaps of business or impact mitigations and other such things. Thank you very much. This is about corporate level grievance mechanism.
Thank you so much, Marina, for these practical insights regarding company-based grievance mechanisms in your experiences. I mean, you shared some very important points. The ones that stood out to me were, you know, the importance of integrating grievance mechanisms into the management system and how it's part of the bigger whole. I mean, part of the reason for these mechanisms is to help feed into human rights due diligence processes. So if you just have a grievance mechanism siloed and not interacting with the rest of the company, that's problematic. The other point that I'd like to reiterate is yours on enabling trust, which is a challenge for company-based grievance mechanisms. Clearly, I mean, when the company is involved in, you know, some harm to a person or community, it's hard for that person or community to think that the company is the right place to go to resolve that issue. And the importance of engaging with the community, speaking to them about before, you know, grievances are even there, about the design of the mechanism, how it functions, but also once a grievance has been lodged, to keep them informed of the process is really important to try to build trust. And then, as you mentioned at the end, the benefits of one of the benefits of having a well-functioning grievance mechanism is that it actually does build trust with the community in the long term, and kind of reduces various types of risks. So thank you so much for sharing that. We have a little less than 10 minutes to go, and I'm not seeing any questions pop up in the question and answer box. So while people are thinking of things to ask, perhaps I'll just start off with a kind of a generic question that's maybe directed to each panelist. So as you know, the working group on business and human rights has a project currently, the UNGPs at 10, in honor of the upcoming 10th anniversary of the Guiding Principles, which is looking back at the first 10 years of implementation of the Guiding Principles, kind of taking stock, but also looking forward to see what should be prioritized in the next 10 years. And I guess with this in mind, kind of looking forward, you know, each of you shared a few thoughts about the current state of play in various countries, and maybe where there's some deficiencies in judicial systems or in mandates of NHRIs or whatever. And perhaps you can reflect a bit on what we should be focusing on in the years ahead. and maybe what can be done to improve access to remedy, you know, whether it be at the company level, the national, regional, or international levels. What do you think should be the focus in your perspective to improve access to remedy on the ground going forward? So perhaps we can take this in the same order of the presentations. So Tatiana, if you have any thoughts on maybe what's the way forward from here?
Спасибо большое. Я думаю, что, по крайней мере, это актуально для нашего региона, что нам необходимо всяческим образом инициировать и стимулировать со стороны международного сообщества страны Центральной Азии для того, чтобы принять национальные планы действий в области бизнеса и прав человека. Мы давно даем эти рекомендации, но, возможно, какие-то международные инициативы или через какие-то международные рекомендации можно будет призывать наши страны к тому, чтобы были разработаны такие национальные планы, которые бы позволили государству выработать ряд мер по влиянию на компании. Это должны быть какие-то меры, преференции, какие-то стимулирующие меры для того, чтобы компании любого уровня создавали внутри себя вот такие вот внесудебные корпоративные механизмы по регулированию споров. Это то, что нам сейчас необходимо, потому что в наших странах есть такая особенность, пока государство не обяжет, никто ничего делать не будет. И это в равной степени относится к корпоративному сектору. Поэтому если государство не спустит какие-то нормативы, не даст какие-то регуляционные меры, не предложит какие-то преференции бизнесу, бизнес сам будет очень вяло реагировать на какие-то современные тренды. Потому что в Центральной Азии есть большое сращивание частного и публичного капиталов, и нету реальной конкуренции в бизнес-среде, поэтому все должно спускаться вот со стороны государства. И одна из таких ярких мер – это как раз-таки национальные планы действий. Спасибо.
Thank you. We are running short on time, so I think we'll just try to keep it at a minute tops, if not faster. We're going to go to Dirk before Anna. Sorry, Anna, because I think Dirk needs to leave at 12:30. So Dirk, your reflections, please.
Thank you very much. Appreciate it. I'll keep it very short. I think the UNGP +10 needs to really kind of look at the differences in regions, because I think we are in completely different places at different regions. I have been working a lot at country level with national action plan processes, which you can criticize for their effectiveness in general, but I'm a strong believer in the process and development of such action plans being almost more important than the result itself, the action plan itself. I think most of the people on these panels here I know, and they are all kind of beacons of carrying this message forward or raising awareness at country level. I think this is so much needed to have more allies in each country that carry the message forward and slowly start raising awareness and building capacity, for which I think national action plans are still a very good vehicle that I think are useful also to drill down on access to remedy at the end of the day.
Great. Thank you, Dirk. Anna, your thoughts?
Yeah, I think that Dirk took my words. So I really think that national action plans are a must. So in none of the non-European Balkan countries, there is a national action plan. And it's really important because I think it will detect all the positive and negative aspects of this topic. And it will really put on the same table the people from different professions. So we will have representatives from state institutions, NGOs, lawyers, and who will really talk and share ideas and familiarize with the topic. So that's one thing. I think that a pressure should be put really on the state and the relevant ministry kind of start the ball rolling. And then secondly, for me, is training and capacities buildings, because we cannot accelerate the topic of business and human rights unless we have trained judges, prosecutors, lawyers, people who work in the judiciary, to really explain what does it mean, to explain what is a due diligence or human rights policy, and why is it important for a company, and how they can assess that when they have a case in front of them. So to keep on 1 minute short, thank you again for letting me step in with a small intervention. Thanks.
Thank you, Anna. Tamar, 30 seconds, please, and your thoughts on the way forward.
Thank you very much. Well, very briefly, that the major challenge in Georgian context is the low level of policy will on implementation of different activities. Implement would be most important and useful for Georgian kind of mechanism to over our state institutions and the government to improve implementation level of different action plans. So this is the main challenge in our context. And from international context, I think that the recommendations given in the NRIS recommendation is really very valuable, and we hope that they will be implemented or shared by the relevant stakeholders. Thank you.
Great, thank you. And Marina, 30 seconds, very quickly, your thoughts on how the guiding principles should be taken forward.
So even there are some, yes, even there are some areas for women or groups from the state side. I think would be useful measures to motivate business to take experience training. Here, institutes like Danish Institute, UN Global Compact, UNDP would be very important.
Great, thank you so much. We are just 1 minute over time, so I think I'll spare any sort of wrap up remarks, but thank you so much to the panel, and thanks for everyone for joining, to UNDP, to the working group, and to the organizers, Insight Pact, and the interpreters. I'm now going to hand the floor to Bob Bernardo to wrap up this day. Thank you.
Ben, thank you so much, and panelists, thank you so much for that excellent panel. I'm here now to provide a short recap of the day and to provide a closure to all the discussions that we have had so far. But first of all, let me thank all of you participants, moderators, speakers for attending the second day of this forum. Again, this day has proven to be another rich opportunity not only to learn, but to discover further entry points and opportunities for expanding our work on business and human rights. Today, we have looked at practical steps in ensuring responsible business are conducted in line with human rights. We have seen also that human rights due diligence is very important, but it should not be seen as a one-time effort or a single tool only by itself. It has to consist of a basket of tools to make it truly effective. It's also clear from the discussions that for human rights due diligence to take place within business organizations, leadership is really critical as an important driving force. At the same time, having a human rights team by itself is not sufficient. We recognize that human rights should be integrated across all the branches and units of the organization. The discussions also noted the knowledge gap on business and human rights among governments, the public, and businesses. We also know and are fully cognizant of the fact that human rights can be greatly politicized. Raising public awareness, as well as explaining to the businesses that respect for human rights will benefit them in the short and long term, are important. And businesses need to be made aware that effective human rights due diligence is indeed beneficial in the long term, as it enhances competitiveness, it builds trust with the investors, and leads to stability and resilience. Having a supportive enabling environment and legislations on human rights due diligence will also diminish the cost to companies and can further improve supply chains management. Today, we also identified some key drivers for human rights due diligence. These include society's expectations, like what was emphasized in Belarus, for example, the push from investors, the push from regulators, as currently happening in Western Europe, and which we expect to have spillover effects in our region soon, or sooner rather than later. And of course, the market pressure for greater accountability and transparency in the supply chain. Going forward, we really need to be mindful of these drivers to achieve the results that we expect and hope for. We also touched upon the need for greater respect for rule of law, particularly in the context of systemic corruption, to ensure that businesses are provided by the state with the enabling environment to comply with human rights due diligence, including incentives and accountability systems for making it happen. Today, we also reviewed common challenges in the region, and there are a number of them, including the lack of mechanisms to remedy abuse. We have heard that this often relates to lack of knowledge and capacity on business and human rights within judicial systems. Training and capacity building for lawyers and judges is needed, but we also recognize that corruption within the judicial system is another important obstacle to address. We have heard very good experiences with regard to how national human rights institutions can play an important role in addressing the human rights violations occurring in business activities. Often, however, we have seen that NHRIs are constrained and limited by rather stringent mandates that they might not include or relate to business and human rights, as well as the lack of capacities and resources. In addition, authorities and capacities to enforce legal remedies can also be very inadequate in many contexts, which goes back to the importance of national action plans, as emphasized in the last panel, and the need to build alliances and partnerships around it. The importance of national action plans, as you have heard, has been highlighted in day 1, and today again in day 2. And therefore, we need to continue that discussion in terms of how we advance national action plans and what do we need to do in terms of raising awareness of its importance. That is day 2, but let me say that the day is not yet over. I invite you to continue the journey with us today and join at 1 p.m. Central European Time, 3 p.m. Istanbul, the side event with Belgrade Center in Human Rights called Volunteerism to Obligation, Business and Human Rights in Southeastern Europe. We thank you very much. We look forward to seeing you in the side event and in the continuation of the forum tomorrow. Have a good day, everybody. Let me turn the floor over now to Kavya for further remarks. Over to you, Kavya, please. Thank you.
Thank you, Bob. This now concludes day 2 of the forum. We will take a short break and be back at 1 p.m. Central European Time for the side event with Belgrade Center on Human Rights. Thank you. Welcome, everyone. Thank you for joining us for the first regional forum on business and human rights in Eastern Europe and Central Asia, making human rights a priority for business. I'm Kavya, and I'll be your technical facilitator today. If you have any questions for the speakers and panelists, please use the Q&A function. If you have any questions about Zoom or require technical assistance, please feel free to privately message Kavya InsightPact for help using the chat box. I will now pass the floor to Sinisha Milatovic, Business and Human Rights Specialist at UNDP, who will be moderating the side event with Belgrade Center on Human Rights. From volunteerism to obligation, business and human rights in Southeastern Europe. Sinisha, the floor is now yours.
Thank you very much. Hi, my name is Sinisha Milatovic. As Kavya indicated, I'm a business and human rights specialist with UNDP. I'm very happy to be hosting this event. This event is actually co-organized with the Belgrade Center for Human Rights, as some of you have seen. So let me just say one thing on a personal note. I personally cooperated with the Belgrade Center for 18 years, dating back to Professor Vojin Dimitrijevic, who was a leading human rights scholar, activist, and a member of the UN Human Rights Committee, and he was the founder of the center. And since then, the Belgrade Center for Human Rights has been doing excellent work on a range of issues, including representing asylum seekers, human rights education, and of course, last but not least, business and human rights. Their director, Sonia Toshkovic, actually talked yesterday in a panel about the work that they've done to develop a national baseline assessment, and I'm sure another colleague of hers, Nevena Kostic, one of our panelists, will talk about that today as well. Okay, so that's by way of introduction of the Belgrade Center. On to today's event. The actual central objective of today's event is to explore the current state of play on business and human rights in Southeastern Europe, and can move the needle in this regard. More specifically, aim to look at how to raise awareness and how to get a conversation about in the region going on how to shift it from a CSR mindset, whereby the focus is on charity, philanthropy, and so on, onto a business and human rights mindset to look at the actual obligations of corporations, looking at how businesses impact communities and workers, looking at human rights due diligence, and so on, in line with the UN guiding principles that are touchstone for all the work that we do on business and human rights in the UN. So with that being said, this session is going to be hopefully, lively, interactive. There won't be any presentations as such, because we'd like to get a conversation going. This is the first panel of its sort under the auspices of the UN, at least. And to kick off, I'll introduce each speaker as I ask them a question. I'll ask each speaker a question, and then we'll have more of a back and forth. To kick off, I'd like to ask Ms. Nevena Kostic with the Belgrade Center for Human Rights, an expert on sustainability and business and human rights. Welcome. And I'd like to ask you, the Belgrade Center developed a national baseline assessment on business and human rights in Serbia in 2016. Can you describe what key issues you encountered in this process? And can you also tell us a bit more about why the process of developing a national action plan since has stalled? Nevena, over to you.
Thank you, Sinesh, and thank you for your kind words. We are very glad to be part of this forum. It was an amazing opportunity to learn more on developments and challenges that we definitely all share. So business and human rights is relatively new to Belgrade Center on Human Rights. I mean, relatively, we started 7 years ago in 2013, when we started to introduce business and human rights concept in Serbia. We started through partnership with Danish Institute for Human Rights. We're working on 2 human rights and business country briefings. And honestly, it was also an amazing opportunity for us to research and learn on UNGPs, as it was important to acknowledge all the novelties that the platform introduced, not only for governments and businesses, but also for civil society. For example, for us, that was even how to speak the same language as businesses do at that moment. So country briefings were based for consultation and dialogue on human rights and business with relevant state, corporate, and civil society actors. And through numerous meetings, roundtables, conferences, our goal was to identify gaps, but also to recognize relevant initiatives that are already consolidating existing efforts in various areas that are in line with business and human rights concept and UNGPs. All that led to national baseline assessment that we'll hope will eventually lead to a national action plan. So the baseline that we did was focused on Pillar 1 and was based on the model that was published by Danish Institute for Human Rights and ICAR. So what did we learn from this process? First and foremost, stakeholders tend to enter this process as and consultation as a ticking a box exercise. So it was clear from the beginning that a lot of work had to be done on creating environment for the creation of action plan and to work on educating what UNGPs are and what is the business case for the action plan. We had to and still have to make sure that the whole process is not seen as tiresome and unnecessary. So that goal remains our major imperative, even on the cost of having a bit of slower process, but more thorough, definitely. So, and I see this attitude as an advantage because when action plan is becoming standard now, that the different stakeholders, including most important international partners to Serbia, like UN, EU, and Council of Europe, are demanding from states, it is important to avoid the trap of making just another document. To us, that is of highest importance, because that is not unusual in the countries that are in the process of EU accessions. So just ticking the box would entirely miss the opportunity that UNGPs are providing, which is to engage in initiative that can address business and human rights issues in the widest scope. And in case of Serbia, including fight against poverty, income inequality, social injustice, and sustainable development. Second, through assessment, we realized that regulatory developments, although necessary, are the least of our problems, as the key lies in a proper and monitored implementation and rule of law. So regarding regulations, numerous reform processes are currently underway in Serbia, and many of which have direct implications in the field of business and human rights. For example, introduction of non-financial corporate reporting, or taking into account social and environmental criteria when conducting public procurement. At this point, at this moment in time, what is playing to our advantage is mainstreaming and general acceptance of Agenda 2030 and its goals. So as advancing human rights is critical to achieving most of the goals, respect for human rights should be at the heart of all state and company strategies. And although to us working on this issue, this is clear, we realize that human rights are the least understood and integrated part of SDGs in Serbia. So in the process of adoption of action plan, it is important to demystify that. And for example, that could be done to making clear simple links, for example, of how monitoring supply chain can bring improvement of human rights in the wider community. And thirdly, as my last point for now, through consultative process, we learned that action plan needs to be tailored specifically for Serbia or the region, and that action plan cannot be copy-paste from other plans, because otherwise no one would truly come on board and take the process seriously. And this is one of the reasons why we find the regional cooperation immensely important. So we can discuss this further later. Thank you, Sinish.
Thank you, Nevena. Thank you. That was brief and informative. And I hope the other speakers follow in your footsteps. Thanks very much. So you mentioned, what a national plan should look like. And now we're going to turn to a man who knows all about national action plans, Mr. Jernej Letner-Černić. He's an associate professor of human rights law at the Graduate School of Government and European Studies in Ljubljana and Kralj from Slovenia. He's also a leading authority on business and human rights, having written a very authoritative book on it, and is a well-renowned academic. So it's a pleasure to welcome him here. Now, we said that our speakers are not necessarily represented, they don't necessarily represent their countries, but I would like you, Jernej, to talk about Slovenia, because it was the first country in the region and the only country so far to adopt a national action plan. So what impact has this had? What impact has the national action plan had on the extent to which businesses actually respect their obligations under the UNGPs, and what lessons could be learned by other countries in the region from Slovenia? Jernej, over.
Thank you very much, Sinisha. It's a pleasure to be at this side event. In fact, Slovenia was the first country to adopt National Action Plan in the region of Southern Eastern Europe, and one of the first in Central and Eastern Europe overall. And we adopted this plan 2 years ago in November 2018, and now we are slowly coming to the end of first cycle of implementation of the National Action Plan. Of course, when Slovenia was discussing National Action Plan, there were a lot of challenges. And one of the challenges was how to translate the language of business human rights to the stakeholders, both in business, state institutions, and also in civil society. Because in Slovenia, and as is true also in other parts of the region, the area of business human rights is often conflated and confused with corporate social responsibility. In Slovenia, so far, until the plan was adopted, the companies talked a lot about donations, charities, and the good work they do for local communities, but no, then they took human rights obligations as a binding. So that was the first challenge. And if you look at the Slovenian National Action Plan, it's kind of particular, and it was also subject of criticism because it also only concentrated on the state responsibility, on the first and the third pillar of the UNGPs, and it omitted the second pillar, which talks about corporate responsibility to respect human rights. And this concentration, the focus on the first pillar was also very much the focus in the first 2 years of implementation of Slovenian National Plan. And I'll here concentrate on your question exactly. What were the impacts? Of course, the impacts, to be very sure, they have to be measured empirically. And this has not been done so far, but I can tell you what have been the impact of the National Action Plan for the state institutions, business community, and civil society. For state institutions, the change which I have seen is that some normative acts have been reformed. For example, the company called Slovenian Sovereign Holding. It's a company which manages the capital investment of Slovenian state. Now urges the companies, also requests the companies to include in their annual reports also the reference to the National Action Plan and how the company implements the National Action Plan in their business activity. Other thing I have seen is that the state institutions have put much more emphasis on the access to remedy. I'm super glad that Slovenia and the Ministry of Industry of Slovenian government this year handled the first case under the OECD guidelines for multinational enterprises. So Slovenian National Contact Point started to function, and they already delivered first decision, which was not the case before the adoption of the National Action Plan. Secondly, concerning the business community, what we have seen with my colleagues when we are reading the annual reports of the largest Slovenian corporations is that companies, much more than before, they put attention to their human rights commitments and obligations. They still do not talk about obligations, but only about recommendations and commitments. So there is also change there. Of course, there are many challenges as to the respect for human rights in their supply chain, and when they operate extraterritorially, for example, in other countries of Southern and Eastern Europe. At least at normative level, there has been a change. And then thirdly, as regards civil society, this is where perhaps I'm a bit discontent with the developments. So there's not a lot of civil society organizations working in business human rights. There are one or two NGOs which provide advice to the companies and to the governments, but overall the whole the whole area of business human rights in Slovenia in civil society has stayed more on paper than in theory. So the challenges for countries which are thinking of adopting national action plan is, of course, to focus on certain areas of UNGPs and to make them, locally understandable. And then also, secondly, to already think when you're writing a plan, how the country, how the state institutions and business stakeholders can implement these commitments in business operations and in the practice of state institutions. So I'll stop here and I can add something later.
Thank you very much, Yanni. That was great. Thanks for that overview. Let's move slightly southward to Ms. Tamara Tucholsky. She is the founder of Impact House Consulting. It's a social enterprise that offers social consultancy. And Tamara, welcome. And just to ask from your experience, drawing on your experience, to what extent would you say businesses in Croatia have taken on board the ethos of the UN Guiding Principles? Have businesses been more likely to understand that they have obligations to their workers, to their community at large? Or are they still focused merely on acts of philanthropy and charity? And how, if at all, has Croatia's membership of the EU changed this? Thank you. Tamara, over to you.
Sorry, I didn't unmute myself. As you know, I'm at the same time a sociologist, a entrepreneur, and a human rights activist. So I don't know which perspective would you like first. But I think actually to combine your question and what we just heard from Slovenia, how can this be implemented by businesses? In Croatia still, we see philanthropy, very unstrategic philanthropy done as a way to, as Ms. Kostic said, tick the box. And then we see a little bit about, CO2 emissions and this kind of things trying to be managed in an old school CSR strategies where you would kind of try and calculate that based on, of course, a lot of government and EU protocols and strategies in place. So we do know that pushing the governments to regulate and pushing the EU to regulate will have some effect. However, as was mentioned before, this is usually lazily done on the ground. So to go back to my three kind of perspectives, I think it would be good to maybe speak as an entrepreneur. I do understand, especially in the crisis, entrepreneurs just saying, look, I'm here to make money. That's my job. My job is to make money. However, at the same time, what is happening is so-called the impact revolution. And the impact revolution, now speaking from the language and the position of the business and what works, we know that millennials are spending differently. We know that they are going to get more and more resources as they, grow up and acquire capital. We know that they are crucial in impact investing, and we know that they have a different view on the impact they want to see from the investments they make, whether we are talking about, a big capital investment or we are talking about just me going to the store and buying something. At the same time, globally, so this is not for Croatia. I think Croatia, is of course lagging behind. Globally, we know about, I think the numbers are about 6% of companies are completely transparent about their value chain, about their supply chains. And, speaking as a sociologist, I do understand we're in a bit of a, hard situation because our impact is so removed from us that it's very hard for me as a consumer to see all the human rights problems I'm causing by buying something, right? So this is what happened with, globalization, mobility, and so on. At the same time, we do have to put in the conversation the crisis, not the pandemic itself, but any crisis that is, of course, going to then impact even more the groups and minorities and vulnerable groups. We know this. I'll give you an example. In Croatia, a lot of the Roma. So I have three companies, and one of the companies has now been was building my company with the Roma community. And now we gave it to the Roma community, which owns it now. However, most of the Roma community, a lot of the Roma community are employed as people who do house cleaning, right? And in the Corona crisis, there is no house cleaning, so they've been really, really impacted hard. So basically what is happening is that, in my opinion, there is this very hard, bloody and hard battle that you have to carry out with the government, with the national action plans, with pushing the governments to do what they have to do to regulate. However, at the same time, and this is what we do so-called social impact hacking, which means that we are trying to figure out ways that the companies can do better by not seeing that as a big cost, but actually as a gain. And the way to do that is, of course, to present client acquisition and client retention through, obviously you're going to make more money and you're going to have more loyal customers these days, and of course continue with millennials growing up, if you can prove that you're doing the impact. So we really have to change the perspective, and I'll give you another example. We at the moment, the crisis, also one of the things that impacted was people growing and buying local food, and we're always running against the issue, but local food and organic food is more expensive, right? The issue with that is that, speaking as a sociologist, so the issue with that is that you do not calculate the costs on the environment, the costs of transport, the cost of cheap labor. So when I'm buying cheaper food, I'm actually spending more, but I'm not spending more money. I'm spending more of my health, of the environment impact, and so on. So it's basically about trying to turn that around and show just a different way of accounting. And this is the last thing. So what is happening is that we do know that the whole idea of market regulating itself, it will not regulate this part until the customers are those that demand it, because then business is in a position where it has to change its practice to keep the customers and to get new customers. So it's basically about changing customer perception, in my opinion, and finding ways for businesses to do it where it's least painful, so that they can do big change with kind of little investment.
Thank you very much, Tamara. That was great. There's a lot of points raised there, and we'll come back to those. Next, however, I'd like to turn to Mr. Kemal Özkan. He is the Assistant Secretary General of the IndustriAll. It's a Geneva-based global union that represents more than 50 million workers in mining, energy, and manufacturing sectors, and it does great work through its global framework agreements that I'd like to come on to. Kemal, as somebody who proves that you don't have to have the same hairstyle that Yevne and I do to do business and human rights, welcome. If you could tell us a bit more about how has IndustriAll helped to prevent abuses of labor rights in the region, including in Turkey, and what role have these global framework agreements that I mentioned, what role have they played? How crucial is trade union engagement and activity in promoting labor rights? Kemal, over to you.
Yeah, thank you. Thank you, Sinisha. As you mentioned, I am from IndustriAll, that is an international trade union organization representing more than 50 million workers in the whole manufacturing supply chain in 143 countries of the world. Let me put what I want to say in a context. This corporate social responsibility programs, we call CSR, rely largely on auditing and compliance to attempt to improve conditions in the factories that they produce for them. These unilateral, voluntary, and non-binding efforts have overwhelmingly failed to improve wages, working conditions, working hours, or to ensure respect for workers' right to join a union. So this is why what we see right now in all supply chains, workers work long hours, often far beyond legal limits. for poverty wages and in conditions that breach health and safety standards, and continual downward price pressure by big companies keeps wages low, while their real value declines against inflationary increases. And the quality employment is precarious. And with temporary contract, agency work, subcontracting the norm, and violation of the right to freedom of association are commonplace. Unionization rates are extremely low. Collective bargaining is very rare. And now we need to have a strategy in the globe for overcoming these challenges. The first is to create an enabling environment on the basis of the human and business rights principles. And this is why, as the global union movement, we are very much in favor of having a binding treaty within the system of UN. And we really want that all international recognized human rights, including fundamental workers and trade unions rights, are in it. And also we really seek access to justice for victims of transnational corporate human rights violations in the countries where those multinationals are located. And in addition to the binding treaty, and we now see the developments in the European Union, we also see the national level binding enabling environment. It started with different countries in France. Now there is a big debate in Germany. You see a flag just behind me. So this Sunday there will be a referendum in Switzerland for legal regulation about multinational companies headquartered here in Switzerland. So this is the enabling environment part. And on the other side, we need to build up new models of cooperation, including the factories, buyers, workers, employers, trade unions, big brands. And this is why we have developed a series of different the instruments with the involvement of everyone. I believe in addition to enabling environment, we also need to the cooperations, collaborative cooperations, constructive cooperations to be able to make these regulations in reality on the ground. One of the instruments we use is the global agreements signed by our global union and the big brands regulating the labor rights, working conditions in their supply chains in different countries. And this is something important for preparing the supply chains with the workers, giving them education, training on their rights. And this is a proactive the way. And also we try to address the conflict cases in those supply chains, in those factories, with a joint understanding between the global union and the brands. I believe this is an area where we need to work quite a lot, because we always claim that the current system of supply chains, value chains is not sustainable. And this COVID-19 crisis has once again shown us that this cannot continue like this. With the suspension or cancellation of orders in many countries, we have seen quite a number of job losses, dismissals, unpaid leaves, and all those workers and countries are now in big difficulty, in big challenge for being able to survive. So this is why we need to be able to regulate the global supply chains. And in the region, indeed, we work in Turkey as it is one of the hubs for textile and garment industry, but it is not alone. We also work in Bulgaria, Romania, Serbia, Albania, and all other countries, together with the brands, for making sure that the workers' rights are respected. And this needs to be supported by joint programs, training, education, not just workers, but also the suppliers. And also we need to be able to address the problems on the ground for improving the working conditions, for better wages. And I can tell you one thing, that now the wage levels in Southeast Europe even are much lower than the wages in China. And this cannot continue like this at the heart of Europe. And most of those countries are candidate or associate members of the European Union, and they work for less money than China or any other country in the world. So this is why now it is a huge responsibility of everyone, of all of us, that we should be regulating the supply chains, and they should not be exploitative. And this is why there must be proper implementation and respect of workers' rights, human rights, so that we can have a sustainable economy, sustainable democracy, and sustainable state structure. So I have put together some context. If there are some questions in later stage, we can dig in some of those points, as there is a huge job over the decades in regulating, managing the global supply chains, particularly from the point of view of workers as the global union here in Geneva.
Kemal, thank you very much for those remarks. That was very informative. I'd like to now turn to our, let's see, last panelist, last but not least, Ms. Ana Dango Hug. Actually, I'd just like to announce, in case you haven't spotted, that even though he was announced, Adil Rahman of ASOS was unfortunately unable to join us at the last minute. Something arose, so he sends his regards. So Ana is a lawyer and leads the business and human rights section at the Interpartes law firm in Skopje. Ana, welcome. Thanks for joining us. One question for you initially, which is, can you tell us, drawing upon your experience in North Macedonia, what role can lawyers play in preventing business-related human rights abuses? Can you give us some examples, perhaps, from your experience? Thank you.
Yeah, thank you, Sinisha. Dear panelists and dear participants, thank you so much for inviting me to this side event. So to answer your question, I think that lawyers play a pivotal role in aiding companies to prevent business-related human rights harms in several ways. So I'll just go one by one. So firstly, I think as corporate lawyers, we are very well positioned to advise clients how to adopt a human rights policy or conduct due diligence or adopt grievance mechanisms. And because this topic is very, let's say not new, but at the early stage of development, very often we are faced with the question that also Tamara mentioned, why should we do all of this when we work according to law? So very often I have a couple of arguments from the business case to say and to demonstrate to my clients that they need to be compliant with international standards. So we are at the stage of explaining the business case and we are far from arguing how they should do it. So for clients who would like to walk on this journey, they realize that the adopting of the human rights policy is not a simple copy-paste exercise, but they really need to see it as a long-term process where they need to engage also different stakeholders from their sector. And then I really place a lot of attention on the operational grievance mechanisms, because I think they're an excellent way to prevent clients from going to the court, where they will be faced with long procedures and are very cost-driven. And that's why we try to draft and then the clients implement sound grievance systems, which go beyond the whistleblower protection, because the whistleblower they already have it. So we try to really fulfill the criteria of the third pillar of the guiding principles. And what I also observed is that with startup companies, it's much more easier to talk about these issues because they're at the beginning of developing their business culture. So when you advise them that they should adopt the human rights policy or operational mechanisms, they're eager to do it and they even want more information about it. And then I think the second stage is the litigation as such. It is a challenging one. Because, as I said, the civil and penal systems are not drafted with the human rights language, and therefore we need to be very innovative how we draft the orders or criminal charges. And as I mentioned in the previous panel, we had in 2019 a case with an NGO. I think you know, Macedonian Young Lawyers Association. I think the Belgrade Center is also cooperating with them. So we drafted as part of a strategic litigation. We had a case, and we still have a case, against state organs, asking the court to rule that the state failed to fulfill their international obligations and therefore violated the right to health, the right to privacy, and the right to a healthy environment. And even though this case is not directed to legal entities, still it is important because we have a lot of evidence which shows that the state organs have failed to control the industry, which is the biggest polluter in the country. And we are waiting for a decision anytime soon. And I think the last, let's say, area where lawyers can be creative in preventing business and human rights is the publication side. So I think that publications are a good tool to familiarize not only your clients or potential clients, but also the public at large, academics, NGOs, about the main notion of business and human rights. And that's actually how I started in 2016 with the Danish Institute of Human Rights. We also drafted the first national action plan on business and human rights. And then during the lockdown, I published a tool on the right to health and businesses, which was very well accepted here in the country. So in sum, I think that lawyers can do a lot to accelerate the discussion and implementation of business and human rights, put it on the table when they speak with their clients or in the courtroom, all in all, for the sake of making the right to remedy effective for victims. So thank you very much. I will stop here and give the floor back to you, Sinisha. Thank you.
Thank you, Anna. Thanks very much for that. So we've heard from all the speakers initially, and as was noted at the beginning, the actual theme of the panel is, aside from the geographic focus on Southeastern Europe, which is how can we shift the mindset from CSR to business and human rights, more broadly speaking. And we've heard a lot of dynamics here at play. These have been, involving basically a race to the bottom. Kemal mentioned wages being lower in Southeastern Europe than in China. We've heard of EU accession as a carrot, and in some places it has occurred. We've heard of regulatory reforms, the weaknesses of unions, et cetera, et cetera. So I'd like to come back to Yevne first and ask a sort of a big picture question. In some of the previous sessions as well in the forum, we've heard Dante Pesce of the UN Working Group mention state capture and corruption being obstacles to strengthening business and human rights. And it was said in those sessions that the market would demand change effectively through investors, through supply chains, partnerships, and so on. But many of the countries in the region play a very small part in global supply chains. So essentially my question to you, Yevne, is what is left if we have state capture and corruption, if we have countries and their businesses playing small parts in global supply chains and little pressure from investors? If we concede all that, what can drive change? Yevne, over to you.
Great question, Sinisha. I mean, our region is characterized by weak institutions, a very weak rule of law, corruption, which is present both in state institutions, but also generally in a private and business sector. There's a particular way of doing business in Southern Eastern, as my colleagues know quite well. So really, it's a good question. I mean, how to go about it. One way to go about it is to lean on the on the support of international organizations. All of the regions, all of the countries are part of the negotiations process to become a member of the European Union. Apart from one country, if I'm not mistaken, Slovenia and Croatia are part of the European framework. All the countries are part also of the Council of Europe, which brings about the rule of law, human rights, protection of human dignity. So, I mean, the normative standards are there, in the countries of the region. But still, what we see from different rankings, also business rankings or perceived corruption rankings, is that the countries in the region are really quite at the bottom of the global rankings concerning the perceived corruptions. The businessmen often say that in order to do business in the region, one has to take advantage of some gray methods. So my take would be to put the faith on the improvement of regulatory framework on state institutions, because business human rights is it's a part of a larger picture. It's a part of a larger picture of the rule of law, respect for human rights, human dignity in the national environments. So when the state institutions in our countries will become stronger, when the rule of law will not be only on the paper but will be fully implemented also in practice, when businesses will be able to trust the local judiciaries to solve disputes in a fair, independent manner, then also there will be the translation effect also to the business sector and also to the rights of victims. Also, there are many comparative economic analyses which say that states which have strong institutions and strong rule of law, then they are also more developed and the wages are higher. They go hand in hand with the improvement of a state institution. So I would put my faith on the first pillar of UNGP's. Countries in our regions, the governments have to make the promises true. First, to adopt national action plans, and then also to implement it in practice by making their institutions stronger. That people in our region, that this slowly start to trust more, judiciary. That the European Court of Human Rights does not receive so many complaints as it does at the moment from our region. So my take is to work on improvement of state institutions, and through that we can also improve the rights of stakeholders and victims in business human rights in our region.
Thank you, Yevgeny. I'd like to now shift that question slightly to Nevena, but in a different form, in a way. Some would say that Serbia is engaged in a race to the bottom. This is the kind of dynamic that Kemal was talking about. Our government here, I'm based in Belgrade, would say that Serbia is open for business, that essentially it's making itself business friendly and so on. And at the same time, this probably comes at the cost of protections to workers and so on. How can this dynamic be changed? To me, it seems it's either political, or the change can be in the mindset whereby businesses can demand that actually what is business friendly is to have essentially more responsibilities, to be shown to be responsible and so on. So my question to you is bearing all this in mind, these conflicting dynamics and this race to the bottom that we have, how can this dynamic be changed?
Yeah, this is also part of the answer that I missed to give. Why is the whole process stalling at the moment? And it's kind of part of the same, and that is, I believe, one of the main reasons that it's human rights and economy developments are completely two separate issues, and no one in government and in wider stakeholders don't see the correlation between them. And making that link would be crucial for moving forward, and also connecting to like CSR and UNGPs, because I think we have in the region, although it definitely stands that at the moment, especially with COVID, we are racing to the bottom in Serbia. But kind of related to a question like how we develop from CSR to UNGPs that you also asked before. Like, I think in Serbia and region, we have opportunity to say that these are two completely different concepts. And maybe 10 years ago, that kind of discussion was valid because it seemed natural that businesses doing good kind of can even more improve to doing through UNGPs. But at the moment, because we have so much developments on the UNGPs and the business and human rights, we have to admit that kind of making the link between human rights and economy would be a crucial thing. And unfortunately, in Serbia, investment is top priority at no cost. And I think that the shift has to be made. It can come, it doesn't have to be, I'm actually, maybe because I'm not expecting the huge political revelation, I wouldn't put all my hopes into that. But I think like the kind of wider agreement of other stakeholders can bring that change. Because we saw during the last few months, so many events that happened are actually and could be resolved if we had a proper understanding of what responsible actions of states and businesses are, like starting with like health and safety issues that were related to COVID, payments, or any other protection of whistleblowers. So the thing is that I think that work that needs to be done in Serbia has to be like horizontal and kind of needs to attack the issue from as many angles as it is possible.
Thank you, Nevena. Thanks very much. I'll now turn to Kemal, because actually he would suggest, in a way, not he personally, I'm putting words into his mouth in a way, but the track record of IndustriALL would suggest that global framework agreements, through these global framework agreements, IndustriALL has done something that, you know, many thought would be impossible, which is essentially convince brands that it's in their interest to let their workers unionize and so on. Some of my research, academic research, was focused on these global framework agreements, and I was, you know, the question that I always had that I would ask brands was, with all due respect, why did you let the trade unions in? You know, just looking at it from a self-interested perspective, what's in it for you? So maybe Kemal, can you tell us what's your trick? What is it that, you know, how did you convince these big brands and their suppliers, obviously in Turkey and in the region, to, you know, to sign these global framework agreements and to let their workers unionize and then to, you know, strengthen their freedom of association rights? Kemal, over to you.
Yeah, thank you, Sinisha. Perhaps I can connect it with the previous discussion about investment versus human workers' rights. And I believe all the investors, entrepreneurs should understand the changing environment in the world and the big transformation in the world. And all the big businesses are now reviewing their criteria for making investment outside or for giving orders to different suppliers in different countries. Now, with COVID-19, everyone, all the business people, brands, big multinationals have realized that they should minimize their risks. And the risk at this stage particularly is in countries where there is a very low protection of human rights and workers' rights. And we have seen this situation in South Asian countries, Southeast Asian countries, This is why all the businesses are now seeking quite the healthy and sustainable places for making business. So this is why particularly the countries in the region should understand the reality that they have to invest more, they have to do more in improving the quality of democracy, democratic institutions, and human rights. Because there are two parts. So the one part you mentioned, the part of the big brands, big multinationals, making investment or giving orders. And they want to make sure that their businesses are not in risk, and they try to take actions in that area. Global framework agreements are one of them, because at the end, there should be a kind of monitoring and enforcement mechanism at the international level to observe what is happening, to intervene in all those human rights issues. So this is the main logic why the brands or big multinational companies are signing global agreements in a proactive mode, accepting international principles, accepting international structures for monitoring and enforcement, and trying to get results. This is one part of the coin that we try to regulate the supply chains at global level. The other side of the coin is the countries. Like most of the countries in Southeast Europe are not the ones producing big brands or multinational companies. They are the ones receiving investment or the orders for their suppliers. Now, what will happen and what is happening? Those countries where there are democratic rules, where there are the labor rights protections, and they are the privileged ones in getting investment. So this is why this illusion in the minds of the government and diluting workers' rights and putting economy ahead of the work is not the way. This is just an illusion. And no one will, no investor or entrepreneur will really invest in those countries for increasing their risks. So this is why, on the one hand, we try to create a kind of international mechanism with the brands, with the multinationals, so that the same rules, same principles are applied in their supply chains. And from the other way around, in the countries on the ground, we try to reinforce the enabling environment and also involvement of all the actors, particularly workers. This is the system that we need to bring together, because it is not just pure economic, it is not just pure legal, it is not just pure for business. It requires a change in mentality, how we are going to run the global economy, how we are going to run the national economies. And it requires that kind of dimension. We always make a kind of distinction between growth and development. Growth is increasing the GDP. I mean, you can increase the GDP, but it doesn't automatically mean that there is a development. We need development. That development can only be done if the human rights, workers' rights are recognized and respected. This is the key issue I want to say. And if we want to talk about democracy, any country without democratizing its economy, it cannot be democratic. And now in the world, the main direction is that those countries with transparency, with democratic institutions, will have much more chance to get the investment, foreign direct investment, will get much more chance for orders in different sectors. So this is why now it requires a real collaboration by all the stakeholders. And at this point, societies, workers are the key. We represent all the manufacturing sectors. Let me give you an example. Auto industry, Serbia is receiving quite huge investment in auto and supplier industries. Now, electrical vehicles, you need battery. And for battery, you need cobalt or lithium or nickel. And now all the auto companies should be able to conduct a due diligence process about the mining part. And this is the mood. If we miss this mood, particularly in the society side, in the government side, in the employer side, then we cannot develop our the economies. So this is why it is critically important to regulate measures that require businesses to adopt and apply human rights due diligence policies and procedures. Any country, any employer, any entrepreneur who takes steps in this area will have much more advantage than the others. So in the region, indeed, what we see right now, democratic institutions are not very well settled. And the economy is the priority in comparison with all other matters, particularly social issues, workers' issues, human rights issues. This is not a good way. This is a wrong way, I need to say. And it is important that in a democratized economy, with the involvement of all workers, then these issues can be addressed. In Serbia, in Bulgaria, every day we receive reports from the workers with intimidation, with pressure. Simply, they just made a free choice to join a trade union organization for getting a protection of a collective bargaining agreement. This is not acceptable. Same in Turkey. My origin country, we see everyday stories. So this is not acceptable. And this is why it requires a cooperation from global to the local with a set of enabling environment, supporting and complementing each other, and also cooperation by all the actors at the same time for a proper due diligence system in transparency and with respect of workers' human rights.
Thank you, Kemal. That was quite a lot that was said there. And you know, I recognize, actually, I just want to comment myself on something that you said, and then I'll bring in our next panelist. You know, you seem to suggest that bigger brands, some of the ones that you have signed global framework agreements with, have recognized that essentially it's in their interest in a way to do this, to let unions in, let unions form, let workers associate and so on, or at least in their suppliers. Actually, paradoxically, I remember when I was doing research, there was no conclusive piece of research showing that, you know, it is a win-win proposition, but still there's been a change in mentality that you mentioned. So with that being said, the change in mentality of brands, I guess one of my questions would be, how do we change the mentality of local businesses here that might not be as plugged into global supply chains? But, you know, coming back to Tamara and the question of a change in mentality, I had a question for her, and then one of our attendees had a question that was better phrased, so I'll use her phrasing essentially, which is, what would be your recommendation for the localization of human rights issues as the global perspective, like child labor, forced labor, indigenous people, tends to be understood as irrelevant locally in the region by both businesses and the general public? And I mean, essentially linked to that, you know, Tamara, you mentioned in your statement that earlier, that, you know, we know the millennials are spending differently. We know that more and more resources are, you know, being spent, and this is crucial in impact investing and so on. We see that, you know, companies see that it's better to be better in a way. So just to link the previous question and, you know, the question of the audience and my own, how true is this? I mean, how, you know, and what is it that consumers care about? You know, do they care about child labor globally? As the question suggests, they don't. Do they care about something else? Is it, you know, local issues? Do we have any data on this, or do you have a feeling anecdotally? What is it that they care about? Over to you.
So yeah, I think that there are 2 points to be made that can kind of maybe bring us towards being, you know, kind of constructive and trying to figure out what to do in the region, because it is correct that okay, you know, being a part of the EU does change things in some ways, because you can lobby in the EU, and then you know, your country has to accept or implement some of those things, which is sometimes due to corruption easier than lobbying in your country. But we are in a region where everything that you already described is true. So I would here go to the chief executive of the Global Reporting Index, Mr. Mohin, who, you know, his quote, the way that he spoke about it was, okay, you know, we now know that 90% of companies, of the biggest companies, actually fill out the sustainability report. That's not new, but what we are seeing is that investors are reading them. That's new. So there are 2 shifts that are happening that can help. One, there is a shift from broadening from sustainability, green, and environment to other topics. I'll give you an example. For example, we've talked a lot about, you know, including environment into accounting, but now you have a movement in UK that is trying to include equality into accounting. And that can be done on a local scale in small businesses where you have new ways of calculating. That includes your costs and your gains, your profits and your losses, not just financial ones, not just environmental ones, but the ones concerning, for example, equality. That is something that can be done through kind of best practices and providing free consultancy and expertise to those smaller companies, local companies that cannot afford to be a part of that kind of a trend. So there is a shift from kind of seeing as your corporate responsibility the environment to broadening that to other aspects. The second thing is that, you know, I don't know why I put myself in a position to speak from a position of an entrepreneur, but somehow that happens. So let me continue. You know, do not show me words, show me spreadsheets, basically. So anything that you want to do with businesses, I don't want to read strategies. I don't want to read recommendations. I'm not going to read a document that's, you know, 50 pages long. Show me spreadsheets, show me an Excel table. So, you know, follow the money. So basically the 2 things that can be done, and we are seeing small change here, is who is important to me. If you follow the money, show me in my spreadsheet. So 1 investor and 2 customer. These are the people that, you know, my business depends on. So then the question that we have when we talk about locally and regionally is, what is our impact investor situation? What is the ratio between investor and impact investor? How can we, and this is very interesting because since we don't have a lot of impact investors, this means this is a new playground for them. This means that the ones that are, you know, ambitious and want to, you know, do something and have their name heard can do it here because there's, you know, not a lot happening here in that aspect. So that's a really opportunity. Sometimes being kind of last or not in the best position is actually, you know, how you can be competitive if we are moving the competitiveness idea also just from financing to, you know, other aspects. So yes, we can be competitive. For example, attracting impact investors in a space where, you know, there's not a lot of competition for them. Secondly, the customers, I think that, and I don't have numbers for you for the region, but I think that, you know, we are lagging behind, but that space between generations is shrinking because a lot of, especially younger generation, actually lives in 2 countries. They live physically in 1 country, but online they live in another country. So also their attitudes change. There's now things such as apps that allow you to follow, for example, the chain of supply of the product that you are purchasing. So there's a lot of technology that is basically, you know, either open source, so it's free, or it's cheap, or it can be done, you know, if you have a hackathon that, you know, tries to get that data from the local entrepreneurs or companies and, you know, offer that as a tech solution, that's also possible. And I think, you know, last but not least, if I look again from this horrible position I put myself in, what kind of things can affect me and what kind of things I'll consider as the CEO. You know, there are strategies, recommendations, and so on. So not a good example because, you know, I'm an impact investor and I'm a social entrepreneur, but still, you know, there is all this recommendations, so on, that's not going to impact me. There is what we talked about, legal framework. And I'm going to do kind of my minimum here too, and I'm going to outsource that probably, unless I have an in-house legal department. Tell me what's the least thing I have to do so that I don't go to jail, basically, is going to be my question. And then thirdly, the way that you can impact me is, of course, financially. And if you look at it, there is green procurement in Croatia and in some other countries. So green procurement is a very interesting case where you're not telling companies, okay, you have to, you know, be green, but you're saying, listen, we're going to have a positive prejudice against companies who are in our public procurement. And a lot of companies, especially local in our region, actually make money by local procurement. Yes, there is corruption, but still, if we go back to the first thing I said, if we expand from just green to, for example, equality procurement, and if we manage to calculate that, so if we change the calculation as well, then through procurement, which is something a state can do and is much more impactful on me as a businesswoman than is a strategy or even law, that's a good idea. And then secondly, you know, taxation, and, you know, if I want to buy a fair trade product, if I want to buy locally grown product, if I want to buy organic, it's going to be more expensive to me as a customer. So how do I, you know, how does the state, or how can we lobby that as a producer, I have some incentive to make things in a, whether these products or services in a, you know, more fair, humane way, to treat everybody that I work with in a better way? Well, you know, there's taxation and procurement going back to spreadsheet and numbers. And the way that we usually work with companies is through the 6P methodology that we use. So we look at, I know I didn't make it 3P, it'd be easy to remember, but I made 6P. So we look at product placement, process, PR, profit, and I forgot one. But so what we do is we look at different aspects of the business chain, which is not what you see usually when you have strategies or laws made for businesses. So it has to kind of speak their language. And then we look at different aspects of production and of selling that product and of the profit, and see ways where we can make it better and also make it doable for the business. And just the last comment, yes, I think there are, but that's very few companies that realize that that's the change of things to be considered, and the huge visibility around their products or services is going to make it impossible to behave in this way in 10 or 20 years. So they're smart enough to do it now, but that's still on basis on who is your CEO and, you know, what are their understandings, not in kind of systematic way of change.
Okay, thank you very much, Tamara. Thanks a lot. I'll come now to Anna. Bearing in mind all this, as a corporate lawyer, in a way, you mentioned that, you know, when you give advice to businesses, they ask what's the business case, and then you presumably obviously tell them the legal framework and then the business case, and you plead with them. What do you focus on? Is it the law? Is it values? Is it what Tamara mentioned, meaning, you know, future trends, what young consumers are doing, how this is going to position them, and so on? And how aware are they of this? Are they aware of this, and so on? And I just ask all panelists, since we have about 20 minutes remaining, just to try and get as many questions as we can to keep it down to about 4 minutes if possible. Thanks, Anna.
Yeah, thank you for your question. Concerning the business case, I think it varies. So I try to tackle different issues, because the most common question is, why should I do it when I work according to national law? And as the UN guiding principles are so far away from our national legislation, we don't have a national base, we haven't done a baseline assessment, neither a national action plan. So in order to approach a little bit the topic, I give them, like, say, the most obvious one, and tell to them first, it's a good thing to do. And for me, it's more easy to speak with a manager who is, let's say, wants to work ethically, because for some clients, the discussion stops immediately. they are ones who say, what I'm interested in is in profit and I don't care about anything else. But if you see that the discussion can continue, then you bring up the other arguments, and very often you end up by saying that, for example, investors are looking for companies who can demonstrate that they are treating their employees equally, that there is no non-discrimination, that they don't discriminate, of course, that they have anti-corruption policy, etc. And what I'm trying to actually to send to them as a message, that it's fun, that it's not something which is rigid and strict and that will hurt, but actually that they should see it in as a new opportunity for them, as a change of the mindset that will actually give a happier employees. Because if you say that the employee should be also engaged as a main stakeholder in the developing of a policy, that's really good for the image of the company. And as we have mentioned, a lot of brands, I don't think people are becoming much more aware where the product is coming from. And it's very bad somehow to restore your reputation if, for example, there has been a case that a child has been abused in your company. So these are kind of the most common arguments that I give as part of the business case. And what I very often bring, and it really depends on the sector where they work. But for example, if you're speaking for, I don't know, a private company that wants to engage in education, then of course you tell them that the children's voice should be also listened. And there are a number of ways to do that, because there are a lot of NGOs that work on children's rights, so they can include it, and that it's a long-term process, and they learn a lot. They somehow, I think, if they see the company as a human being, that they grow with it in a more innovative way, let's say. So this is the way I present it, and then I kind of leave them time to see how it goes. And what else I do is we have a kind of a pitch. I made a short video of 3 minutes. That's for the CEO, and whenever I'm preparing for a meeting, because very often everything is new for them, I just play the video, and it's in English and in Macedonian, so they can have kind of a picture about what are the steps that they need to take. And then I give the video for them so that they can also share with their colleagues, and then they can come back to me. So that's my approach of dealing with these questions of why, because when it comes to how, it's easier for me, at least. At first, you need to kind of, unfortunately, convince the business community, in this region. Thank you.
Thank you. I'm going to go back to something that you said actually in the previous panel, because Anna was in our Access to Remedy panel this morning earlier, for those of you that weren't there. And she mentioned that national action plans are a must. And I just want to challenge that slightly, that orthodoxy in a way, even though our program of business and human rights, our #1 thing is to develop national action plans. But on the one hand, Sonia, the Belgrade Center director, mentioned in a panel on national action plans yesterday that we don't want to create something that gathers dust on a shelf. So my question is to Nevena and to Yevne, as one from a country that has a national action plan, another that developed the national baseline assessment and that saw the process for developing a national action plan stall. My question is, how do we sort of thread the fine line? How do we walk the fine line between, creating something, bearing in mind all the action plans and all of the things that have gone unimplemented? What is it that we can do to demonstrate the value added of this? Is there a value added? I mean, I would assume that there is, but considering everything that we've heard about, people being tired of implementing action plans and so on, how do we do that? What angle do you come at it from? Is it sort of, we have to do this because others are doing it? Is it that, this is going to cover new ground that isn't covered? Is it that it's going to help the business case? What is it? I mean, perhaps, Yevne, I can go to you first and then
Yeah, this is one of the challenges also Slovenia has faced in this first cycle of implementation of Slovenia National Action Plan. I can tell you that for example, the membership of this implementation supervision group was mostly forming part of the members of state institutions, different ministries, representatives of academia, and there were very few. Business stakeholders. So that, of course, is one challenge: how to go beyond this saying that we in Slovenia we preach water concerning business human rights, but then in practice we drink wine. As many alleged violations in the private sector tell us. Of course, one thing to go about it is to invite businesses in the implementation process. There is no point of having national action plan without involving businesses in this process. And in this respect, the state has to be the leading role model. So it first has to ensure that business human rights are protected in the companies where it has capital investment. If the state does not, it does not implement the UNGPs in the companies where it has capital investment, then there is no point even for private companies to internalize these principles and values from UNGPs. One of the things Slovenia did, what the Slovenian ministry did, is that last year it organized the first Slovenian National Forum on Business Human Rights and invited many companies, many of the largest companies from the Ljubljana Stock Exchange, and most of them came. And it also offered them to write, to sign a statement of compliance with the Slovenian National Action Plan and UNGPs. And some of them, they signed the statement. If not mistaken, probably Mrs. Natasha Bregal from the Ministry of Foreign Affairs would know better. There are around 15 to 20 companies which signed this statement. So not that many. So the other thing is also to try to, at least the state institutions try to measure the compliance with UNGPs in the business operations of the companies. One thing I find not only in our region but also globally in business human rights that we struggle to measure empirically the real impacts of UNGPs and other standards for daily lives of workers and also local communities. We don't really know how UNGPs affect the change of corporate culture, And in our region, unfortunately, there hasn't not been really substantial research done in this area where we would measure the impact of companies in their business operations. We in Slovenia, we have now a project where we try to measure empirically the business human rights in the largest Slovenian companies, those which are listed at the Ljubljana Stock Exchange, and we basically adopted methodology which is used by a organization called Corporate Benchmarks. So this could be a way try to inform businesses, because as my fellow speakers said, businesses see national action plans and UNGP as a further level of regulation. And here in Slovenia, most of the companies and industry chambers are very, very reluctant to get involved in this process, because they see that there are so many regulations coming at them that it's just too much to follow. Just taking into account EU non-financial directive, the conflict diamonds regulation, which is now coming into force in the EU on the 1st of January, and now also the draft of the EU regulation on the due diligence. So there's a lot of discontent among businesses now, especially large businesses, because they see this regulation as expenses. So the way to go about it is to involve them in discussion, and of course insist from those businesses which are owned by state, that those businesses, without any exceptions, have to implement UNGPs, and they have to also try to measure the impact of the National Action Plan in their business operations.
Thank you, Yevgeny. Nina, the $64,000 question goes to you. How do we make the National Action Plan super fun, attractive, and where everybody wants to do it? Tell us.
Well, I've seen a lot of action plans that didn't work out in the last many years, but for this one, I actually still think that it will make sense to have it, because it could possibly make that bridge between businesses and human rights that really, despite all CSR efforts and everything that is going on, they do not overlap. And for that, we need to have like a thorough baseline assessment, and we need to identify what are the salient issues in Serbia and in region. But then, in order to identify that, we need society that is transparent, and we need less corruption. And I see transparency as a major issue, because by working in the business and human rights field, I know much more and the essence of the businesses that are not in Serbia and in the region. And we basically hear about issues and problems only when incidents or some dramatic things happen, which is an immense problem. And as Kemal said, as long we have to work on business and human rights and integrating it in the system, but basically we always still have to work on the basic principles of rule of law. And another thing that Tjerni just mentioned, and I made the note to mention it myself, is the impact that state-owned companies have in the region and in Serbia. And that is the kind of point of difference between our region and other parts of the world and EU. And maybe that could be a good kind of first step to impose compliance in those companies. But on the other side, to be honest, that seems like a harder step, because a lot of private companies that are working in Serbia are well aware of business and human rights, UNGPs, and they're implementing that. But they're implementing that under the radar. They're implementing that because they need to report to their headquarters. So that has nothing to do with Serbia. They're not doing it for Serbia's sake. So it's a pretty complex. And another I will just drop another question, and that is the role and importance of small and medium enterprises in all this. They are making the huge part of the business and corporate scene in Serbia, as they're employing so many people. So maybe next time we can also touch upon how we can come to them, because maybe there we can find a lot of partners that we basically cannot reach because of lack of the capacity that we have. So yeah, a lot of open questions.
Thank you. Actually, in preparation for this panel, I went on the UN Global Compact website, and I started, I put in the filter, the countries from the region, and then I put in, I wanted to see basically how many members of the Global Compact there are from the region. And you have categories, the way they filtered it is companies and then small and medium enterprises. For some reason, small and medium enterprises are not companies, but hey. And there were actually a surprising number of small and medium enterprises from Bosnia, from Croatia, from Albania, I was shocked. So I started, I guess I had too much time on my hands or something. So I started looking at their reports and letter to the Secretary General and so on, a company that employs 22 people or something in Western Bosnia writing to, it was impressive in a way. Made me think maybe there's more going on underneath the surface that we don't know about, or is this simply them being wise to the fact that, it doesn't no harm, there's no cost to it. You're reporting, it's a self-assessment. Why not? I don't know. There's obviously two ways of looking at it. So in closing, I have a question for each one of you. You each have a minute exactly, 60 seconds, and then I'll kick you off the panel if you go above that. So the question is, this is a regional panel. if you will. Now, obviously there's lots of things that tie together this region, but is there anything that we could usefully learn from each other? I mean, considering all this, and especially, are there economic links that we could use? Is there anything, because this is a question from the audience, I'm just reshaping it in a way. What are the kind of dynamics or points of future cooperation that you can usefully imagine in the region? And we'll start from my left to right. So I'll say Yerne first, you have 1 minute.
Well, I'm super glad that Sinisha, you managed to organize this panel, because I was not aware that so many people work in business human rights in Southern Eastern Europe. So this is the first way to get connected and also try to work in this area, both in civil society, academia, consultancy, and also on the government level. Myself and my colleagues Beata and Olena, we recently established a subchapter of Business Human Rights Association, subchapter on Central Eastern Europe. So that could be a way for us to connect. And we are also planning for 2022. I know it's quite far away. We are planning a special issue of a Business Human Rights Journal, and the call for papers will be out soon within the next months. So this could be one way to work in this area and try to build this field of business human rights in Southern Eastern Europe, which so far has not been so much present in global discussions on business and human rights.
Thank you, Yerne. That was a minute. Tamara is next. Tamara, go.
So I would say, look at what we think are our disadvantages as our advantages. One, we are a new territory for impact investment. And two, we are perceived as a region from the outside. Even if we don't perceive ourselves as a region, major companies are not going to have a company in each of the countries, going to have a company in one of the countries, and they're going to perceive us as a region. They're going to have the head for CSR if they have one for the region, or for the PR, or for the legal department. And then this is our way to impact on the regional level.
Thank you. I would agree with that 100%. Thanks. And Nevena is next. Nevena. Oh, if you can unmute yourself. Sorry.
Okay. Yeah. I also think that this is an amazing opportunity. We start to think about ourselves as a region from the perspective of investors and companies and international organizations that just wanna work on issues with us. And just using my last 20 seconds to say, we also need to use more skills and expertise within companies, because they do understand metrics, they understand reporting, and they do understand accountability. And so I think that bond needs to be tighter in the future.
Thank you, Nevena. 57.5 seconds. Excellent. And now Anna, go ahead. The floor is yours.
Yeah, thank you. Just to add up what they have to add something new. I think that if we decide in the region to develop national action plan, and of course there are pros and cons to it, then I think that there should be a kind of a platform for lessons learned, because the history of the region is showed that we have very similar national legislation, both civil, criminal, and corporate, and therefore I think for this new journey we can go together. Of course, it will be different. Every country has its own specificities, but if we can learn something from each other, then I think it's an added asset. Thank you.
Thank you, Anna. Point taken. I agree. And then the last word goes to Kemal. Kemal, go ahead.
Thank you. Thank you. Indeed, in the region, we need economic development for prosperity and happiness of people. The region deserves much better than what we have today. And we need an economy based on the interests of people, together with people, not to people. And it requires dialogue with the involvement of everyone. We may not be able to agree on everything, but it is a big responsibility for all the sections of the society to be able to find the common points on which we build up a society, an economy altogether. And then it is important to exchange experience, information, and it is also important to be able to see the big picture and what the reflection could be for the region. And I believe this kind of platform is also serving very well to that purpose. And we will continue to work together. We need to work together because the region really needs that kind of cooperation, collaboration among different partners, stakeholders in the countries.
Thank you, Kemal. That was excellently put. I couldn't have done it, put it any better myself. So I will just stop here. Thank all of you very much for dedicating your time and for your insights. And I thought it was very interesting, and it was certainly the first of its kind that I know of. So let's hope that next year forum we can get to do it again. So thanks again very much. Thanks again to the Belgrade Center for Human Rights, who were our co-organizers. And thank you to all those who attended. I'll now hand it back to Kavya, who from Insight Pack to close the session. Thank you.
Thank you, Siniša and the panel. This concludes the side event with Belgrade Center on Human Rights, from volunteerism to obligation, business and human rights in Southeastern Europe. Day 3 of the forum begins again tomorrow at 9 a.m. Central European Time. Thank you all and have a wonderful day.